started. It is July 8th, 2024, 9:09, and I will call this meeting to order and ask Board Secretary to record the roll.
Chair Diani.
Present.
Ms. Carpenter.
Present.
Ms. Grimes.
Present.
Mr. Spraggins.
Present.
Ms. Young.
Present.
Mr. Gutierrez and Councilmember Suara are not present.
Okay, thank you. So we have a quorum, thank you. And that moves us to item number 2, public comment period.
I don't believe anyone signed up.
And we don't have anyone signed up at this time. Okay, thank you. So that brings us to item number 3, agenda item number 3, approval of the minutes of June 5, 2024. The minutes have been provided to all board members earlier, a week ago, I believe, and we have them in our packet. I hope everyone's had an opportunity to review the minutes from the meeting of June 5. And I will now entertain a motion to approve the minutes.
So moved.
May I have a second?
Second.
Any discussion? Hearing none. All in favor of approving the minutes of June 5, say aye.
Aye.
Opposed? Hearing none. The motion carries. The minutes of June 5, 2024 are approved, which gets us to agenda item number 4, notice of appeal rights, and I'll ask our secretary to provide that notice.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. Okay, that brings us to agenda item number 5, and I believe we have the parties here and we are ready to go. So we will start with the hearing on the amended complaint, Joseph v. Carol McCoy Arts Commission. So we will turn our attention to that case now.
May I ask a question on that? I have filed a motion and I need a point of order, and that is the motion taken up before we proceed to the merits?
No. You mean the motion to dismiss?
Yes. Based on my affidavit and all the papers that have been filed.
Yes.
And I assume that all of you have read everything.
So we actually had our initial hearing on the amended complaint, and at that point, and I believe you sent a representative.
That's not the motion that's before you today.
I understand. This is a substantive motion.
It is.
Right, with an affidavit, which we would consider factual evidence, written testimony. So that goes to the evidentiary hearing, which we have scheduled for today.
Correct.
So that's where we are today. We're at an evidentiary hearing, as we do, under our code procedures.
I didn't have that before you the last time.
The affidavit?
No, the affidavit wasn't before you,
That's true.
and my motion wasn't before you.
That's true. But we've progressed past the motion to dismiss. So our process is legal reviews the complaint, and if any of the allegations were found to be true and it would constitute a violation of the code, we then consider, we'd go forward if we find that. So we've already dealt with the motion, kind of like a 12B6, we've already dealt with that process, that part of the case, and we as a board voted to proceed to hearing, which would provide an opportunity for both parties to present evidence to us in the form of documents, videos, testimony, affidavits, stipulations. That's where we are today. There had also been a motion here to continue.
So
we considered that.
I'm hearing you say is that there is a valid complaint of some sort that violates whatever provisions are in the code.
There was a law memo, which I believe you should have been provided with, that reviewed the amended complaint and found, as to several of the allegations,
Right.
there was no basis.
Correct.
Did not state a cause,
Right.
and we dismissed those.
Correct.
The law department memo did say that, broadly speaking, considering everything, there could conceivably be, depending on what evidence is shown, it could make out a violation of K, standard of conduct K, undue influence. Now, we are here today to test that.
I don't
We
mind
voted as a...
but I do think that
Okay, I think we're going to proceed, so I'm going to ask you to, I understand your question, but we are not going to take up your motion to dismiss
Go ahead.
first. We are going to proceed to the evidentiary hearing on the case. That said, I hope both parties have received copies of our procedural rules, both under the code and that we have adopted as a board of how we proceed. We try not to be overly legalistic because the purpose of this board is for a place for members of the community to come when they have concern that there's been an ethical violation. This is not, we do not want to be overly legalistic. We do not want citizens to feel like they have to engage with an attorney or hire an attorney or know something about the law. They come, they articulate their view to us as members of the community from different community organizations, what the nature of their concern is. And so, that said, we still want it to be an organized discussion, so we do have a certain formality to the way we proceed, which is we start with opening statements from the complainant and the respondent, which is optional, discretionary, you need not do it. And then we go to a presentation of the case in chief from the complainant. Now, case in chief could be a position or facts. If there's a witness, there would be direct cross-examination and redirect. Here in this case, we understand there's no complainant's witness, so it would merely be the case in chief would be a presentation of the position. At that point, we would then go to the respondent, who could then present facts, witness facts, affidavits, and then the same thing. There'd be an opportunity for direct, redirect, and direct, cross, and redirect if there were a witness. Otherwise, there would be a rebuttal case if any new facts came up, and then we would have closing arguments. So opening statements, a summary of the facts that are most key, most relevant, what you're going to show, and then closing argument to make the pitch for why there is or is not a violation. That's how we proceed. Yes.
Madam Chair?
Yes.
I hate to do this, but our hearing procedures do say any preliminary motions, stipulations, or agreed orders are entertained. I don't know if the motion to dismiss is a preliminary motion, but just for the sake of whatever body reviews our decision, maybe we should take up the motion to dismiss, deliberate about it briefly, and then if warranted, go on to the hearing.
Yeah, I don't know how it's not duplicative, though, because it's not a motion to dismiss if obviously, it's not 12b-6, right? Motion to dismiss if it's based on an affidavit and facts, that would be more of a Rule 56, a summary judgment. It would be a trial on the paper. That's what summary judgment is. We're talking, it's evidentiary. So I just don't, I think it is not consistent with our existing process. And it's a preliminary motions could be motion to eliminate, could be motion to defer for another day because of a witness. Those are the kind of a motion that's the sort of thing I think that contemplates, not a 12b-6.
Okay, that's good. That helps me just for the record that we don't view this motion to dismiss as a preliminary motion. This is more of a substantive motion.
Did you want to add anything?
Yeah, I just wanted to state that it sounds like we're saying that the motion to dismiss that the respondent filed doesn't qualify as a preliminary motion, stipulation, or agreed order that we need to entertain before the hearing. So I agree with that.
Okay. Anyone else have any thoughts or?
No. To the extent that the respondent is going to rely on the affidavit, it's not signed or notarized, at least the copy that I have, and I just wondered if we have a signed and notarized copy.
you don't.
Okay, so we may be able to take it in as oral testimony then? Okay. All right. That said, if no members of the committee, so again, that's the general procedure. Our burden of proof is preponderance of the evidence, which everyone's familiar with, which is more likely than not. And I want, again, the board members to know that at any time during the hearing, board members may ask a question of a party, of counsel that is here to assist, or a witness. In this case, there won't, or any witnesses. All right? Okay, so we may begin, and we will start with the complainant. I understand that there's no witnesses, so we will, and that the case really isn't a document case, really. But again, if you would like to make an opening statement, a very brief opening statement, not to the whole case, but just a very brief opening statement, then we'll let the respondent make a brief opening statement, and then you can present your position. Okay.
All right, good morning, everyone.
And we did add this, if you would like to, you need not. If you prefer to stay there, that's fine. Okay.
I'll wait. I'll
Okay.
come for the
Okay. Okay.
chunk of it. So I wanted to start off by offering the definitions of, or what I am defining as the violation, and how I want to focus the material on those definitions. So the violation is shall not give reasonable basis by their conduct for the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties, or that they are unduly affected by their kinship, rank, position, or influence of any person. I want to highlight two of those phrases in this violation. The first one being the reasonable basis by their conduct for the impression. For me, I believe that this was written in the code because of the limitation community members have in bringing material evidence to this board. For instance, I cannot FOIA request personal emails between, say, Alan Valentine, the executive director of the Nashville Symphony, and what he was saying to commissioners at the Art Commission before the August vote, because that's their personal email. I can't FOIA request phone calls, I can't, obviously, and I can't look at it, and I'm not going to look at their social media and look at who, what galas and where they're donating to. So this limits what I can provide as conduct as what I am seeing in the public, so at commission meetings. And that is the material that I'm bringing to you today. I am characterizing conduct as her voting habits and also her interaction with staff, and also her motions during these meetings, revealing the impression, and I think that that is an important word here too, that we need to weed out corruption in our commissions, that we're not beyond a doubt that this commissioner has not been influenced, and I think that's why that term is there, revealing an impression that she has been speaking to and engaging with white-led, white organizations, and also directors in Metro who would like to overtake the department as well. And that the impact of this is that it has benefited white-led art organizations and has been a deterrent to working class artists. And then for the second phrase that I would like to focus on, or that they are unduly affected by their kinship, rank, position, or influence of any other person. I think the word kinship is super important here, that I believe McCoy has a tendency to dismiss people of color and the barriers that are presented to us when we are applying for Metro Arts grants, and I'll go into that a lot more for the February 15th, 2024 meeting. And so she has a kinship to promote other white-led organizations and white artists to the detriment of the rest of Nashville.
Again, this is just this is just an opening, unless you want to blend it in, and this is your case in chief.
No, I just wanted to check on the definitions.
Okay.
And then the last part I want to say, I want to make sure we're on the same page about racism. I understand that this board is not here to judge whether a person is good or bad. I think there's a tendency when we talk about racism to make it a moralizing question. and I'm not asking you to judge whether Carol McCoy is a good or bad person. What I am asking you to do, and the argument in this case, is that systemic racism and the power dynamic is not merely a prejudice or interpersonal conflict, so I don't want this case to be belittled down to I just don't like Carol McCoy or I don't like her opinions. If I was in a Kroger and I heard Carol McCoy say to someone that there's no such thing as an organization with a budget of $25,000, which she said at a commission meeting, I would have passed by that and not thought much of it. But the problem that I'm presenting you with is not something that I disagree with, but rather someone who has the systemic power to enforce her bias and give the impression that she is working on behalf of other organizations and peoples and not all of Nashville.
Okay.
So lastly, I want to speak to the implication.
This is just an opening statement. I'd like you to be a little bit more succinct.
Yes.
Okay.
Okay. I'm asking you today to send a signal to all boards and commissions in Nashville that the corporations cannot merely influence a commissioner to funnel millions of dollars from the government into their pockets and just can't nominate a friend or a commissioner or board member to receive subsidies. Any impression of corruption should be weeded out immediately. And I also did not consult a lawyer to bring this case before you, and I don't believe that I should have, as you said in the news.
Correct. Okay. Thank you. Commissioner McCoy, would you like to make an opening statement? Okay. So now you've, in terms of your case in chief, you have, again, you have a document case in a sense. You have documents broadly to include videos, reports, minute meetings, and so forth, Google Docs, Excel sheets, a lot of video and so forth, which you have, in a very organized way, presented to us for ease of our review. We have had your material at least a week, and we've had, I guess, exactly a week. And I trust that all of us have had an opportunity to really review the materials that you've attached and so forth. And then you also, so how would you, how would you like to present your case in chief? I mean, there's so much here.
I can start with the first accusation and the material, the points of the material I would like to focus on. If we want to save the second accusation for another date, I'm open to that.
Yeah, no, I think we'd like to resolve this today.
Okay.
So the first accusation being the vote in August, and the second accusation being participation, maybe the moving party on the termination of the contract with the Baltimore consultant Dana Parsons. Is that right? Mm-hmm. Okay. Okay. So those are really the two actions that we're looking at, and then below the two accusations or allegations, you have you point to all of the other attachments to bring out this idea of undue influence, to tie it to the code. That's how I see this. Is that accurate? Okay. So you'd like to start with the first allegation as to the vote on August 17th. So we'll start there, and you can present your case for why that was a vote that was unduly influenced. And we don't have a strict time limit, but we are mindful of time for everyone. So if you can be as efficient as possible. And again, you've provided the materials, so we have it. Okay.
So the first accusation, Carol McCoy as Arts Commission discriminated against Black, Indigenous, people of color, and working class artists and voted to defund us on August 17, 2023, despite the vocalized wishes of the community, Metro Council, and the director. So the materials that I would like you all to focus on is the MHRC report, the first being the quote from the nomination interview with council. It's interesting to note that McCoy, when interviewing in March of 2023, so just a few months before this August vote, for the role of the Arts Commission mentioned that this would be a non-conflict entity. And when pressed by the council, she gives a story about not funding the art monopolies in favor of smaller organizations who may not have grants writing experience. I want to first go ahead and say that this quote is still very racist. This is what we call nice racism, the idea of these poor people of color, they need support, and I just want to mention that because I don't want anyone to assume that she had good intention, and again, that...
Okay, and I'm going to try to distinguish what an evidentiary hearing is about facts. Now, at the end, you'll have an opportunity to make a closing argument. That's where you can say, this is how I interpret the facts. But for your case to us is to tell us what facts you have that this person, this respondent, violated the code. So focus on the facts, not your interpretation of the facts, because that can come later. You can then tell us the argument, okay?
So I'll just, I'll read the quotes then, instead of doing the interpretation. We'll come back to that. So she says during that nomination interview, people who come in who just want to start a new venture, their application is woefully poor. You wouldn't award anyone that money until you thought it would be handled properly. The one I remember was a Chinese New Year's festival. It was a little group of people getting together, and I think they asked for $5,000, but the grant was just so poorly written. Maybe if they'd gone to the Center for Nonprofit Management, they might have gotten some help. The other quote that I want to focus on in the July 2023, I want to focus on the fact that she abstained from that voting, or from voting yes or no, and she has not given a reason why for that voting pattern. In the MHRC report, when she is asked, she simply answers for August, and the answer that she gives in August is Jim Schmidt, one of the commissioners, was the former chair. He said, I don't know why we're pitting art agencies against each other. We have more money than we've ever had before, so we will be able to fund a lot of new Thrive people. I was listening to him and thinking that made sense. So that is why when the vote came up for scenario 1, I thought that we had not been keeping our word. So again, she's not responding to July and why she voted, was one of the few to vote against equity in July. And then for her explanation for August, she's blaming another commissioner. The other quote that I want to highlight is also in the MHRC report. I'd like to say that I had good recall, but I still focused on how we needed to change a very complicated formula in 4 days. That's obviously inaccurate between the two months that they had. Let me think. I don't really remember focusing on what she said that much. When she said that, I did not focus on what Metro Legal was saying because I had just listened to Marianne Bird and Father Dexter and Jim Schmidt. I don't remember the big scheme of things where Metro Legal said something. The other, in item 4, during the August 17th commission meeting, she then unmutes, so given these quotes, she then unmutes to clarify, and wrongfully so, that the grants committee, which had met prior, and which she is still a part of, did not endorse scenario 1 simply because her voice was dissenting. And that obviously was inaccurate. The committee had voted to endorse scenario 1 before the commission, but she deliberately unmuted to let people know that she was dissenting, and therefore, because of her singular dissent, that was not an endorsement for the committee. This shows the commissioner, well, I'll leave the interpretation. Item 8, importantly in this clip, as someone who was in attendance, we see McCoy, who was unwilling to hear MHRC. And this is important because, as you can tell from her affidavit and from the financial statement that she presents, there is clearly one director that she is listening to and advocating for on the commission in opposition to other directors in Metro and the council members as well. So 8, that meeting from November 16th shows how she was treating a Black director of Metro Arts, and also the woman of color who chairs that committee as well, who are advocating for Nashville artists. The last items I just added there so you can see the impact. I think when we talk a lot about legalese, we forget about the human impact in this. So I think the timeline and the grants funding model show you who has not been funded. So I want to highlight in the last item in the grants funding model that the two really important organizations that were never funded in Metro Arts history, the Jefferson Street Sound Museum and the Jubilee Fisk Singers. And that becomes the impact on our community when we have commissioners like McCoy.
Can I ask a question about that last point? So historically, for funding purposes, does an organization have to submit an application, or does the commission identify organizations in the community that they would like to fund?
So I'm not sure how it was run in the 80s. It seems like there were other systems, but currently what Metro Arts does is that you do have to file an application.
Okay.
There are severe restrictions. So for instance, my organization in Mahabba Center, we have arts programming, but I can't apply for general operating because I am not an arts organization. We also have a diaper bank and we have tutoring programs and ACT. So I can't get general operating funds for art programming. That is reserved for organizations that only do arts, and you can imagine who most likely is to open up a nonprofit 501c3 that only does art. So that already is a systemic barrier, which means that I then am left to apply for Thrive, which historically has been very little money compared to the general operating. So you can get 20, 30, 50, 6 figures from the general operating. Thrive used to be at $4,000 and then $9,000, which for an arts program, it's not a lot of money. The supplies itself, not a lot of money. So you can't really run a program on that money. And a lot of artists, before the equitable changes were made, could not even apply because it would take 10 hours to fill out this grant application. And it then goes to a grant selection process from the community, and then people are awarded the funds.
So I just want to clarify, do you know whether the two Black-led organizations that you just mentioned applied for funding?
I am not sure, but I am not also sure that the Symphony and the Frist apply for funding. I think that they are guaranteed those funds.
Okay, and then a follow-up question. You mentioned the Thrive program. Can you respond to the statement from the respondent's affidavit that the, I guess it was the MHRC or somebody in their report found that that program is operating outside of the guidelines of the commission?
I have a very long response for this.
Okay.
It's very.
Should we wait until?
Maybe,
Okay.
maybe. Let's let the respondent put on that case, perhaps. Okay, thank you.
Just a point of order, Madam Chair, is she going to come back and talk about accusation 2 later? I think she's just gotten.
Are you completed? Have you completed your case in chief?
So I presented the facts. I still have the interpretation for the end.
Right. So she's presented the facts.
Including about accusation 2?
The Dana Parsons.
I can go into. I didn't do accusation 2.
But is there? I mean.
Yes, there's more stuff. I think if we do it one at a time, I think it's better.
No. I don't. No. I'd rather just have your facts, your case come in. Musical chairs here, but. So just again, just the facts on the Dana Parsons issue, just the facts, and we can interpret. You can give us your argument later. And again, Dana Parsons was a consultant from Baltimore who came to Nashville, right? Was hired
There was a bidding process, yes.
to help the anti-racist camp process?
Yes.
Did they do the PowerPoint? There was an anti-racist PowerPoint?
I'm not sure.
Okay.
They did a
Well,
lot.
I'll let you tell us the facts that are relevant to this question.
So for item 1, this was a meeting that I attended. I can give the testimony here. Between the July vote and the August vote, the executives of the arts monopolies asked to meet with Director Daniel Singh to advocate for defunding Thrive. Singh refused to meet privately and instead met with them in a meeting open to the public. I attended this meeting via Zoom. The directors mentioned how important the $2 million earmark was and that budget size should not matter in funding. Several BIPOC community members pushed back against defunding Thrive for the sake of art monopolies getting more than their allotted 6 figures.
So are we talking about facts that relate to Respondent McCoy? That's really what we need to use your time for.
I mean, it's the basis to show that she's replicating the same language that was at this meeting from art executives.
Okay, well, tell us about those. Okay.
Because again, I don't have access to their emails or what they're telling commissioners.
So, okay, so you're saying there was this meeting where our executive said one thing, and then in a subsequent meeting, Respondent McCoy said the similar things.
Yes.
Okay, so, okay, so that's the facts you're telling us now.
Mm-hmm.
Okay.
So this is my the testimony.
And this is kind of what you have on this page.
Yeah, item 1.
That it was these items. I see you've summarized these facts here for us, right, in page 3, where you've told us the parties, Amanda, D. and Moyer, and is that right? Is that what we're talking about now?
I think in the page before. Yeah.
Item
1.
It's two-sided. Yeah.
Okay.
Yeah.
Okay. Yeah, so there's this meeting August 7th before the August 17th vote to try to rescind the vote already with the art monopolies meeting with the director. What's really important about this meeting is that the art executives threatened the director of Metro Arts very directly, saying, in essence, if they do not receive that additional $2 million, and remember the council had already delineated it to Thrive, they will halt all advocacy for Metro Arts and bypass the department for funding if since they have the ear of the mayor. So I want to put that as the first item to kind of give you who the players are and that they are ready, even after the July vote, are coming in to have a meeting with the director. And the language that they are using is you're not going to get Metro Arts money if we don't get this money. So item 2 is back to that November 16th meeting, but I wanted you to focus on something else for this part of the accusation. In the first part, I wanted you to focus, or I'm asking you all to focus on her interactions between MHRC and her kind of dismissal of their labor and the human rights complaint. In this portion, this is not recorded, and this is part of my testimony as someone who was there. The meeting notes are also inaccurate, but it is during this meeting that we first hear Carol McCoy say she can't read 11-point font on a PDF, so she derails the agenda item, and she begins to rant that she will line up with what Director Crumbo has released on June 12th, 2024. So the items that you find in that audit from June 12th come up all the way early, before even the audit begins in December, in November. She cited the issue with consultants, but couldn't show where she got that information from during that meeting. Director Daniel Singh responded to her during that meeting and said he was short-staffed. He only had 6 staff members, and the department to fully run required 15 staff members total. He was woefully understaffed, he explained, and the hiring process, the Department of HR would not let him hire at the end of the fiscal year. So, but at this meeting, he introduced 3 new staff members. This was the first derailment during that meeting.
So again, I mean, now you're getting into actually, I think, a piece of this complaint that we dismissed. I mean, I don't know, these comments in the staff meeting you brought in your original complaint.
Why I bring this up is to show that she brings it up again in February. When there's
Yes. The motion to fire
Yes.
consultant. Okay.
Yes, so she's already speaking about consultants And the deficit, she's not mentioning these words per se.
Okay.
Without an audit already in place, the audit begins in December. She's already.
December of '23.
Yes.
Yeah.
So she's on the, and we couldn't even get through the agenda in November, and she's derailing the meeting to discuss the consultants,
Okay.
and then the finances. The audit then begins in December. She's not there for the meeting January. February, she brings up the same exact arguments, but for much longer.
And
of the
then that's
commission
when there's a motion in February
Yes.
to
meeting. Yes.
terminate the contract or
Yes.
something with the, okay, Daniel Parsons, okay.
So she brings up the consultants, Director Daniel Singh responds to her, and she then brings up the second very notorious point that I will come back to is these Thrive artists are not real artists, and brings the commission into a conversation at that point about real artists. She mentions, to my recollection, that these are people who are making up projects for funding, and what is the vetting process to make sure that these are people not going to Kroger and that type of rhetoric. She says more specifically, we don't know what they're using the money for, and basically is deriding against Thrive recipients, which is the most equitable solution in Metro Arts. That meeting concludes with her motioning to create the oversight committee, and I believe Will Cheek is the one who seconds that motion. That committee, after its creation, meets in February. The first meeting they have is to hear Director Kevin Crembo speak about how the audit process is going. To me, the timing of those events, that the audit had not even begun yet, that a commissioner is already suggesting that there's a deficit, that there's financial imprudent, whatever is going on, without any evidence, and then all of a sudden is creating a committee which now has not met after the firing of Director Daniel Singh, shows to me that she was speaking and coordinating with people higher up and not listening to community members and not prioritizing the MHRC report and equity, which is what most of the public comments were about. In item 3, we basically see the same scenario again for February 15th. It's a 3-hour Arts Commission meeting. I will go way more into depth about this meeting to answer your questions about why Thrive was under attack and that rhetoric. Item 5 is the audit, and we do have a response to it as well. Or item 5, sorry, is the specially called Arts Commission meeting from Director Daniel Singh. He has his settlement, and then conveniently the audit comes out. And I will speak more to that timeline as well. Item 10 is also an important meeting. It's from the Grants Committee. Sorry, the timeline is not, it's jumping in time. But the March 13th Grants Committee, an artist asks Commissioner McCoy if she's ever read the grants application, since she is part of the Grants Committee. And McCoy deflects and says she receives many, many emails. You have no idea how many emails I've received, and does not even want to consider the grants process that the community put in place. So that's a little snippet from that meeting. And the other one that I just want to quickly highlight was item 12, the Arts Commission's Grants Committee. This meeting, we have the Finance Department speaking about Thrive being illegal and giving their interpretation of a 10-year-old grants program. Well, it's not a grants program, McCoy will say that, but I will call it a grants program. A grants program that they are now deeming illegal, and they, McCoy is in agreement and is in favor with Angela Deaton-Moyer, and again, there were public comments before that period to talk about protecting Thrive and not dismissing it as illegal. The item 13 is just another article about what is going on with the finances, since that seems to be the reason why Dana Parsons, or the alleged reason they're crafting to say they had to fire Dana Parsons. And then 14, I want to just highlight a good note in all of this was that the substitute budget did give an additional $2 million to the arts. And so this kind of puts us in the same place we were at last year, where we have the additional funds, but we don't have the willingness of the commission to vote equitably, possibly. So just again, to end on the note about the human impact of what's going to happen here today.
One just quick question on the first page, on the first paragraph about the early 23, what Respondent McCoy said in the Rules Committee. That's when she was being appointed, right?
From the MHRC report? Yes.
Right, but it's
From the Rules Committee.
The Rules Committee. That's when she was being, the question was she going to be appointed? And the Rules Committee is made up of Metro Council members who were interviewing potential commissioners to appoint them. And this was after Mayor Cooper had appointed her or nominated her, and then she went before the Rules Committee in early 23.
Yes.
And this concern she raised in her appointment interview with Metro Council members was her concern about standards and formal, quality of grant applications, whatever, as you described. That was her as a nominee to be appointed, and then the Rules Committee went forward and appointed her to the commission. Okay, I just wanted to make sure I've got the timeline straight.
Yes.
Okay.
Maybe an important point to name here was that during that time, there was advocacy from individual organizations and small organizations in particular that earmarked $2 million be given to fully fund Thrive.
Yes.
And in the midst of this, you have a mayor appointing Carol McCoy.
And the Rules Committee approving of her appointment.
Nominating and then approving, yes.
Okay, thank you. So now I do have a preliminary kind of housekeeping question right here. Do you, let's see, so you are the respondent and you are going to give testimony. I mean, we understand that you will be providing testimony, so I just wonder if you will then be serving as a witness. You should be sworn. What are we doing here? We usually swear.
I don't mind being sworn in, but I would have thought you would have sworn her in.
So she wasn't, that's a good point. She, I was seeing it as her having a document case. She doesn't really have any firsthand knowledge. She's doing a lot of interpretation and analysis from existing documents. So I think you're going to actually give us some key evidence through testimony, from what I understand from your affidavit. So let's just swear her.
Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Yes. First, I want to thank you all. I know that I asked for a continuance, and I greatly appreciate that the hearing was set at this point in time. And for that, I thank you. I want to also say that I think each of you shares something with me, and that is that you serve in a volunteer capacity, and that's how I am on the Metro Arts Commission. I am a citizen. I volunteered to apply for the position based on my former history with the Metro Arts Commission, where I reviewed probably 80 grants when I was on the Tennessee Arts Commission. I want to make sure that the statements in my affidavit are entered into the record. I am over the age of 18 and have personal knowledge of the facts set forth herein. I was appointed by Mayor John Cooper, my appointment of which was approved by the Metro Council in March 2023. In July 2023, I abstained from voting on motions regarding funding and conflicts of interest. From the time that I was appointed in March until the vote in July, I had no idea how any entity or person would get any money because it wasn't identified in any of the documents that I had. What we had were scenarios that indicated that if an organization was over 3 million, they might get cut 90%, 80%, 10%, or they might get what they had received the year before. I was somewhat surprised when I went to the hearings and I heard representatives from various agencies say, we were told if we went forward with this new funding formula, we would get no less than what we got the year before. This happened at 2 different meetings, and different organizations came. The first time I heard it, I was thinking, I didn't know anything about that. The second time, I definitely didn't know anything about it, but I did ask a few questions. Because I didn't understand how the funding of agencies would work, I abstained. I didn't talk to anybody because we were told at our first meeting that we could not discuss anything with any of the commissioners, absent being present at the board meeting. I inquired of the then director, does that mean that I can't invite one of the new commissioners to get to know them over lunch? And I was told no. I did not correspond with anybody by email. I did not correspond with members of the public except to acknowledge that I had received their emails. I did correspond with the executive director. He did not answer my questions. He did not respond to my emails. On August 17th, 2023, I voted in the affirmative on several motions to fund arts organizations and Thrive applicants based upon a scenario presented by Dana Parsons, a Baltimore, Maryland consultant, whose services were secured by the executive director. I did that, as has been represented to you, based on the statement of Mary Ann Bird, who had gone back through all the minutes of the Arts Commission and said in December of 2022, it reflected in the minutes that any agency that had been previously funded would receive no less than the amount they received the year before if they agreed to the new funding formula. There was no qualifier. The director had stated to them earlier in our meetings, you didn't listen to me. I said you would get full funding. If we got full funding, you would get no less than what you got the year before if we got full funding. He never explained what full funding meant. If you asked a question, it was never answered. The Dana Parsons individual was hired by the executive director. If you read the audit report, you will see that he hired her slightly under the $25,000 that is required to have a 3-bid minimum. He did that 4 or 5 times, all in violation of the Metro rules and regulations, and it is not only unethical, it's also illegal. I didn't know that. I didn't know that he had been keeping this woman on a retainer over a year and a half to make the equivalent of about $145,000 to advise him on a scenario for how to fund the arts organization. I did not know that he was hiring individuals not as employees, but by contract, which deprived them of all of their rights as civil servants in Metro government. He had taken employees who had worked in the Metro Arts Council for years and put them on this status. There is quite a bit of information in the audit in which you will find a number of irregularities. I didn't know that. But after we voted in August, and I voted because of what Mary Ann Bird said, and Father Dexter Brewer, a person of color, who said, if that is what we said, I agree with you. We have to keep our words to the individuals. Now let me present that what happened is that we were given $1.8 million, the same amount that we'd been given the year before. That would have fully funded any existing organization that had received money. In addition, there were $2 million additional dollars for funding artists. That would have provided a great amount of money for any of the new applicants. In fact, there were a substantial number of Thrive artists and new organizations called micro that were funded. Some of them were not fully funded because $2 million will only go so far. But it was so much more money than the Arts Commission had ever received. That is why when Jim, can't remember his last name, he was the former chair, said, why are we pitting the arts organizations against each other? It didn't make sense. Why would we do that when we had so much money to give to all the artists? I also did not know that Thrive was a well-intentioned initiative that was started about 10 years ago. It started by giving 3 or 4 artists about $4,000, either $2,500 or $4,000, can't check. That's what it started at. It is not authorized by the Metro Charter, the code, the rules and regulations. The only entities to which Metro Arts properly can give money is to 501c3. So the Thrive money that was given was not in keeping with the rules and the requirements, but nobody paid any attention to it, and it grew. By the time I became a commissioner, it had gotten to the point where the amount that was being given was $20,000. When I came on, there were 20 individuals who were getting $20,000. The requirement is that if you are a contractor with Metro, you have to sign a contract. And the work that you do becomes Metro's. This was one of the problems with the Thrive individuals. Thrive artists weren't signing contracts that conveyed their artwork to Metro. I am not an artist. I like art. But I am very concerned about money. That's my background, and I want money to be properly accounted for. The Metro Code, Chapter 2.112H, defines the Metro Arts Commission authority to award funds to a non-profit charitable organization or non-profit civic organization. The code did not authorize the Metro Arts Commission to grant funds to individuals nor to entities that are not a non-profit based on my understanding of the provision. Pertinent portions of that code are attached. My vote on August 17, 2023, and all my comments made for funding were solely based upon my understanding of this provision of the Metro Code. According to the order issued by this board on May 1, 2024, I am required to respond to an allegation that I violated Section 2.222.020, parentheses K, close parentheses, of the Metropolitan Code. Pertinent portions are attached. The precise language of the Metro Code Section 2.222.020, parentheses Code K, close parentheses, states as follows. Employees, and here I quote, K, shall not give reasonable basis by their conduct for the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties, or that they are unduly affected by the kinship, rank, position, or influence of any person. I was not and have not been influenced by anyone for my vote, nor have I unduly enjoyed any person's favor because of my vote or my comments. I have not been unduly affected by the kinship, rank, position, or influence of any person in the exercise of my duties, votes, or comments as a commissioner of the Metro Arts Commission. After voting in August 2023, I requested an audit be conducted by the Metro Arts Commission finances because I was concerned about malfeasance and/or misfeasance. Metro Arts audit recently completed reflects that my concerns were warranted. Audit states that the administration of Thrive Awards as a procurement violated the Metro Code and the Code, the Metro Code and the charter, and Metro purchasing rules. Audit report, page 21. In addition, the audit states that Metro Arts does not have a process in place to monitor operating grant and Thrive Award recipients to ensure award amounts are utilized as intended. Audit report, page 15. The audit and these two findings in specific demonstrate my concern was warranted. I did not give undue preference to any nonprofit charitable organization or a nonprofit civic organization, but I was unable to discern how Thrive Awards of $20,000 each could be audited. The legal issues surrounding Thrive Awards and how they develop was addressed in observation 9 of the audit, Thrive Award classification, which states, the appropriateness of classifying Thrive Awards as a procurement transaction should continue to be reviewed by Metro Arts. The Metropolitan Code and Resolution, I'll delete the number, explicitly state and grant that grant given by Metro Arts can only be distributed to nonprofit, civic, and nonprofit charitable organizations. In 2014, Metro Arts obtained permission from the Metropolitan Procurement Agent to allow individual artists to be treated as a procurement activity for the establishment of the Thrive program. Allowable procurement activity in the express content was to apply in limited circumstances. Specifically, allowable activity was to engage artists in a variety of venues on a very small engagements. Small engagements were defined as an item not exceeding $4,000 in cost. The Thrive program has expanded to no longer conform with the procurement agent's approval. As award amounts have increased over the years, additional approval from the procurement agent was not sought. Additionally, the nature and type of activities conducted by Thrive recipients varies significantly. The nature of some activities is more in line with a procurement, while others are more in line with a grant. For example, grants award funding to a recipient for the recipient to achieve its own goals and objectives consistent with Metro Arts. Procurements typically would be used for the direct benefit of Metro Arts and seek best value. Administering Thrive Awards as a procurement is in violation of Metropolitan National Procurement Code, the Metropolitan National Code of Laws, and RS 2001-749, and increases the risk of the integrity of Thrive Awards being scrutinized. Now, having said that, I renew my motion to dismiss this because I cannot discern how voting constitutes a violation of the code section with which I am alleged to have violated.
Okay. Any questions for this?
Questions?
So you mentioned that several times that the art executives talked about agreeing to the new formula if they were going to receive the same amount of funding they had previously received. Why would they need to agree to the new funding formula?
I don't know.
Why is that necessary?
I don't know. I wasn't there. Whenever it happened in December, I came in March. I knew none of that, and I never found out why.
Prior December.
The prior December.
December 22, you came in March 23.
Right.
Okay.
I would never have recommended that you promise anybody anything. That doesn't make sense to me. Why would you promise any entity that they're going to get the same amount? Because one of those entities, I've been quoted about some Chinese New Year thing that I heard 10 years ago. What she deleted was, I also mentioned the Nashville Symphony, that white racist organization. The Nashville Symphony was on the verge of filing bankruptcy. When we looked at their application for a grant, the individuals who were doing this said, we're not giving them any money because their finances are in such disarray. We didn't award them any money at the same time that we didn't award a new emerging little organization whose grant application was woefully inadequate. They didn't answer questions. They didn't do what they should have done to get an award. So if you listen to everything, you will find out that some things don't make sense, and I don't know why you would promise anybody that they'd get the same amount. They might have gone bankrupt. Why would we give them the same amount of money? I wouldn't promise anybody that you're going to get an award.
So you mentioned, and forgive me, I don't track dates of things, but there was an initial vote to adopt scenario 1 at some point, which was described as the most equitable scenario. In July, I guess that was the July vote.
Yeah, I'd barely gotten my hands around. Scenarios kept changing. It used to be 1, 2, 3, 4, 5, and then it was A, B, C, D, E, F, and the last one was always changing, but you're correct. It was in July that there was a motion made to approve, maybe it was scenario 1, I don't know, but whatever it was, I didn't understand how it was working, so I didn't vote. I abstained.
You abstained from that vote? Okay. That was my question.
Yeah.
And in that vote in July, there were 8 yeas, 3 nays, and 1 abstention, and you were the abstention.
Right.
So there were 3 nays, 1 abstention, 8 yeas. For
And
the
so-
July vote, the most equitable.
Your testimony is that you abstained from that vote because you didn't understand the funding
Right.
formula? Okay.
And I had watched the video that Dana Parsons had provided. The director, I kept saying, I don't understand how this is working. He said, just watch the video. Well, I watched the video, I still didn't understand. Because, as I mentioned, there are no specifics. You're talking about a group 1, group 2, group 3, group 4. Who's in group 1, 2, 3, 4? You don't know where the money's being dispersed to.
So the funding formula that you did vote on at a later meeting, did it spell out who was receiving the funding in those groups?
If it did, I don't remember.
Do we have any way of knowing that?
You know, I'm just looking at the vote. They were you're talking about the August vote. Then they took I'm looking actually at the summary from the MHRC report, I believe. That's on page 28, provided by the complainant, that summarizes all of the votes from the July and but I don't know if we have the MHRC report here.
It is.
Oh, it is here. Do you know?
Misuse of materials.
Okay, so, and that's page 28 of that report, and it has the December vote, and Commissioner McCoy was not appointed at that time, so the July vote showing 8 yeas, 3 nays, 1 abstention, Commissioner McCoy's, and then the 2 August votes, and there may have been more, the August vote for the most equitable, and the August vote for the, what's captioned, the least equitable. And in the, so do you see it on page 28? Do you know which?
Yeah, I see that, but what I'm looking for is the scenario, and I see on page 26 of that, I guess this is the MHRC report, it shows the December 2022 vote. I understand Commissioner McCoy wasn't on the commission at that time. It shows the July 20th, 2023 vote, which Commissioner McCoy abstained from. And then it shows the August 17th, 2023 re-vote of funding scenario 4, which I understand Commissioner McCoy voted in favor of.
Correct.
But what I'm seeing on this is it still just has categories. It doesn't say who's receiving the money on this table. And so I'm wondering, was there some of the information presented to you at the time of that vote that told you who the money was going to?
And that's what I said, I can't remember.
Okay. We don't have that anywhere.
I think that there's a video of that meeting that I watched a while ago. And my impression, and we can perhaps ask, but my impression was that they did this kind of scenario vote, and then I think they ended up doing separate votes for each of the size categories. So the size categories, the large, the medium, the mid-size, the small, the micro. I don't know.
That sounds familiar.
Yeah, and then, so I think they did the kind of quote formula votes, these scenario votes, and they got there, and then they then had a series of voting. They then voted on the individual organizations. So in the large category, these are the organizations, and that's when someone would have to do a conflict of interest, I think, something like this.
Yeah.
Does that
At
sound
this point, I
familiar?
don't remember.
But
Looking
there's
at all
a
of
long
this.
series of voting.
Okay.
Varies by size.
Okay. I have more questions, but I'll let someone else, if they have questions.
I have a pretty straight, easy question, I think. Ms. McCoy, you testified that you didn't talk with other board members outside of board meetings, is
Not
that right?
supposed to.
And is it true that you also didn't correspond with arts organization representatives or talk with them about these issues outside the context of board meetings?
I remember two people called me. They are people that I know. Susan Short Jones, who is the former Metro legal counsel and a personal friend of mine, called me to ask me what was going on because she's the president of an organization. And that was before any of these votes, to the best of my memory. The arts entities, anyone who had applied for money, were really worried that they weren't going to be getting money. And I did not realize when I applied to be on this commission how traumatized it had been over the last 4, 5, 6, 7 years. I don't know how long they've been in difficulty. But I was trying to figure out how to explain when people would call. Another person was Liv. And she's also a member of a different organization and wanted to know what's going on. That's the best that I can recall.
And do you know what organizations Ms. Short Jones and Ms. Liv?
I think she was the ballet, and I think Liv is the opera.
And what did you respond to their questions?
I told them that I did not understand what was going on and it was very confusing. I didn't know where the funding was going to be dispersed. You couldn't look at any of these scenarios and tell who was going to get what because, as I mentioned before, they're all by income levels. Nor did I know how much they had asked for. I still don't know how much they asked for or how much they got, if they got anything. I don't know any amount that went to any organization or individual today. That was not, financial information was very hard to come by. And it was in November, the meeting that wasn't recorded, in which I received for the first time financial information that greatly upset me because the director had taken $700,000, and I believe I provided you all with my little printout sheet. He had taken $700,000 from grants and put it into consultants and professional services. In 2022, that amount was $220,000 total, consultants and professional services. What is professional services? If you have a large piece of artwork that needs to be moved, you need to have professionals move it. If you have a computer that goes down and you need to have it fixed, you need to be able to provide for it. Those are some of the professional services that an agency would employ. Consultants. Why would you need consultants? Well, I didn't know, but $220,000 was the amount in 2022. In the first year, the director increased that amount to $450,000, of which $140,000 went to Dana Parsons in violation of rules and regulations. There was another consultant, $25,000 thereabouts, also not put out to bid. When I saw that $700,000 had been taken from grants, which is the money that we wanted to use to give to artists, was being moved to consultants and professional services, I have to say, I lost my cool. I was a little outraged, and I insisted, one, that we have a budget and finance committee for the Metro Arts Commission. We didn't have anybody on a budget and finance committee. I made a motion for that, and I was told that was improper, that it had to be the executive committee. I also requested that the money be transferred back into grants so that we could fund the artists that we are supposed to be supporting. That's what triggered me. So I hope that answers your question.
No, thank you. Other than Ms. Short-Jones and Ms. Liff asking you sort of what's going on with funding, did they ask you to do anything, or did you
No.
tell them you would get back to them?
No,
or do anything?
there was no request. I think that people just wanted to know what was going on. Not knowing causes a lot of concern for anybody. One of the things that I remember is the Tennessee Repertory Theater fellow said, we were told we were going to have the same amount of money, so we've gone out and signed up artists, the script writers, the director. We've made commitments based on the fact that we were going to have this money. And now we're going to get cut 60% of, what are we going to do? We can't even start our series or whatever it is that the Tennessee Repertory Theater does. I think that was the one. And I was sitting there going, that causes a lot of anxiety for anybody.
This communication you're talking about was in a hearing?
Yes.
Okay. This was public comment or, yeah?
Yeah,
Okay.
public hearing.
Yeah.
I'm not,
Right, okay.
just not chit chat.
Right.
So I think a lot of what was happening in the arts community were a number of these individuals who just wanted to know what was going on. And I just wanted to know what was going on too.
And other than Ms. Short-Jones and Ms. Liff, do you recall any other arts organization representatives?
Oh, I remember
contacted you?
something. Former Metro councilman from Bellevue called me in August. Charlie Tigert. I have never talked to Charlie Tigert before in my life. He asked me what was going on, that he had called the executive director 5 or 6 times because he wanted to help a Nashville artist, Michael McBride, to do a mural at the new Bellevue High School. I know Michael McBride. He coached my kids. He's a great guy, and he's a great artist. I said, I don't know why, but I will reach out to the director. So I sent him an email and said basically what I just told you. No word. In January, I was the only person on the grants committee because so many board members had left. We'd had 2 resignations of our chair, and the third one had just resigned, or she resigned shortly thereafter. But I was invited to come and meet Sydney Davis, who was the new grants director. And we sat, 3 of us, and I asked her, what are your qualifications? She told me they were excellent. She had gone to Fisk. She had worked in grants for 5 years at Fisk. She had other qualifications that made me think she would be dynamite. And then I turned to the director and I said, why did you not call Charlie Tigert back so that we could get some funding for Michael McBride? And he said, they're going to get their funding. And I was surprised because I never heard back one way or the other. And I said, well, I still want that $700,000 to go back under Miss Davis because she's in charge of grants and that's where the money needs to be. As a result of that conversation, I called Charlie Tiger to say, did you get funding for the murals? And he said, we're going to do it. And I relayed what had happened. He said, oh, no, what happened was he and Mr. McBride went to a civic luncheon. I think it was the Kiwanis, maybe, could have been a different kind of civic organization, in which the director was the speaker. And they went up and spoke to him about trying to get funding. And he said, the director said, when he was telling me about this meeting, that it was going to be taken care of. So when I talked to Mr. Tiger, I said, are we giving you money? And he said, no. We talked to him. I introduced him to Mr. McBride, but there was no discussion. He said, I've gone out to like Ace Hardware and they've agreed to donate the paint. Mr. McBride has gotten the students to help him do the murals, and he, Mr. Tiger, was going to raise the additional funding. But the way that it was presented in our little meeting was that Metro Arts had done it, which was a true mischaracterization. The director did not want to fund murals. Any artist who was doing a mural, they would not get funding. Thus, when it came up as a question at some point, the director said that we needed to have a consultant at $25,000 that he had selected to tell us what was necessary in order to fund an artist who was going to do murals.
I think if those three conversations are the only ones you remember in terms of conversations with people affiliated with arts organizations outside of public hearings.
Yeah, I mean, I put my little thinking cap on, but I did not intend for the Metro Arts Commission to consume as much time as it has. Like you, I thought I would come in, attend a few hearings, go to committee meetings. It has consumed an enormous amount of my time. I'm very fortunate that I'm retired.
Any other, do you have questions? Like that.
Can I ask a question?
Well, let's see, let's just see, is there any other questions right now among board members? Okay, so is there anything else you'd like to put into the record for your?
Well, I want to thank you all for the enormous amount of time that you've spent on this matter. It is one that I think is wholly outside the purview of what was intended by the charge that you were given under.
And you also will have an opportunity to make a closing argument. But if there are any other facts, because I think we have, so you have been sworn as a witness and you were providing
I think
testimony, so.
Yeah, if you've read the audit, you have enough
Okay,
information.
so you will, so the way we work, we do then allow the complainant to ask questions.
Sure.
Of you. Okay, so you can ask questions.
So in your affidavit, the 10th point, you mentioned going to Director Kevin Crumbo to request an audit. Can you elaborate on that?
I called Metro Legal and asked that an audit be conducted and was told that you had to ask finance. This was either the first or second week in September, and at that point, I think the mayor had not yet been sworn in, and that there was no finance director. So I just sent an email to the finance department and requested the audit. My recollection is that was early in September. Mid-October, I received a phone call. I was out of the country. It was from Director Crumbo, who said that he had received my request and he was going to take it very seriously and he wanted to meet with me. We met. I told him exactly what I've told you. I didn't know if it was malfeasance or misfeasance, but there was something really wrong going on.
Do you want to just distinguish those two words for the board?
Misfeasance is when something wrong is being done and the person may be ignorant of the violations that they're committing. Malfeasance is with intent.
Okay, so one is a kind of a wrong and one isn't.
They're both
kind of
wrong.
innocent. Okay.
They're
And
both
one is-
wrong.
One is.
And you can be responsible
Right, right.
for the wrong actions.
One is intentional and one
intent
is
makes it
not intentional.
kind of
It
criminal.
was unintentional, but there was an error versus an intentional wrong. Okay. And you weren't saying one or the other, but you said something's
I
wrong
didn't
with
know
the numbers here.
something wrong is going on
With the numbers. Okay.
Are you aware that there's a history within Metro Arts of commissioners reporting Metro staff,
No.
white commissioners specifically going after BIPOC staff?
No.
My
I'm
other-
sorry. I'm sorry, I missed something there.
Yep.
Can you repeat the question? Was she aware of what?
The history, the very recent history within Metro Arts of white commissioners reporting BIPOC staff
When you say reporting, what, can you just elaborate?
at whatever to whatever department in Metro.
Reporting like a complaint or something?
Yes, so in this case to
Complaining
finance,
against- okay.
In other cases to HR, so pulling in other Metro departments for this, commissioners pulling in other departments against Metro Arts staff,
Okay.
equity workers specifically.
Okay, so,
With with that explanation, does that change your answer?
you did.
I'm not sure I really understood what's going on.
The question was, are you familiar with the history of Metro Arts,
White
white
commissioners
commissioners in Metro Arts
pulling in other departments or
reporting Metro Arts staff
Yes.
to other
No.
departments,
I-
Metro departments?
I didn't know any of the previous members on the commission when I came on. I didn't know any of these people personally. I knew Father Dexter Brewer because I went to St. Henry's. He'd been there briefly.
But you knew. Okay.
Was Dr. Brewer, was he a commissioner? I'm sorry, I don't know
He
who.
was a commissioner.
Commissioner, okay.
Well, he was.
Yeah.
The only time I knew that a complaint had been filed by anybody was when the director tried to fire his assistant, and
Is this Director Singh?
Director Singh fired his assistant, who was a BIPOC person, and she appealed it, and a lady from the community, who I have come to know, represented her, and she was reinstated. And she, in my opinion, deserved to be reinstated, and I like her very much. So I was upset when she got fired, and I was happy when she got reinstated, but I didn't have any, I would have gone to the hearing if I'd been available, because I did feel that it was unjustified.
Okay.
But you were aware that Jim Schmidt, you knew that he had previously been chair of the commission?
Someone told me that he was the chair. Did he do something?
Yes.
Oh, I didn't know that.
Okay, so the question is, was she aware that Jim Smith was
I barely
the
knew.
prior chair
I had
of
a hard time, thank
the
you for
Arts
the
Commission?
name.
And the answer is yes, you were aware that he had been the prior chair. And then the follow-up was she aware that he had, was there?
No, just I'm curious at what history she knows, what history
Okay.
she doesn't know.
That's all I know.
Are you aware that MHRC in particular has other interpretations of Thrive not being illegal?
I have read some of the MHRC reports. If it's in there, I've read it.
Do you believe that funding only to nonprofits is equitable?
Let's think here.
That's not my decision.
So let's see, so what a cross-examination is, help me
Well,
here later.
it needs to be a cross-examination of the
Of
facts.
what she said,
not-
factually, it's not an interrogation.
I'm asking because she has made the point of, I want to follow the code.
Right.
And so I'm just asking her opinion. That's great if she wants to follow the code, if she believes that the code is equitable. And I'll make this point when I come to the closing statement, I'll just.
Okay. Anything else at this point? Okay.
Oh, sorry, one last question. Why was it important to know exactly which organizations were going to get funding? How is that going to influence or not influence your vote?
I think it's the knowledge and specificity that is important to making proper decisions. I don't think you favor one over the other. I had not looked at any of the grant applications. I hadn't seen any of that in the times that I went to the grant meetings. I understand that that was taken away from the grants committee and given to kind of a community gathering. I have no idea how it was done, so I'm not going to speak to it.
I'm sorry. So the question is, why was it important to know the identity of the organizations that were receiving funding, that you were voting to get the funding? And your answer was you thought it was important because?
Specificity and knowing how much each entity would be getting. It was like the Repertory Theater, and they had asked for $75,000. That's information that I would have looked at, and it might have registered. If I saw the Chinese festival, and I saw they were getting $15,000, it would have maybe registered. There's somewhere in the neighborhood of between 80 and 120 of the, what I would call the traditional organizations that got funding. I would peruse that like you do any type of a document to see where people fall into it. I might not agree that one organization should get as much as they are, but I'm just one voice on the commission. But that's not the way they were doing it.
So from your perspective, were you needing or wanting to know the specific organization in order to make some sort of assessment or judgment about whether they deserve that money?
I don't think you can do that. The way that I had understood the grant process was you were given a big 3-ring binder, yay big, and every grant application was in there. And there were specific questions that were asked as to how were they going to use the money, whether or not they had gotten a clean audit in the year before, what kind of audience would they be serving, how many people would be reached. This is like 10, 15 years ago that I did this process. And then there was a score sheet over to the side, 1 to 10, and you would rank, like how many people were they going to reach. You might say, if they're reaching 15 people, you might not give them a high score, but if they're reaching 2,500 people, you might give them a high score.
I'm sorry, you're not describing the current process.
No,
you're
this is
describing
what
the previous.
This is what I was used to. So when you ask me, would it make any difference about knowing which entity and how much they were getting, I was expecting more of what I had experienced in the past about the quality of the grant application, not so much the entity. How you fill out a grant application. Some were very compelling because they were doing a lot of good, like the Children's Theater. They reach a lot of kids. They may not have the best finances. I'm making this up now, I don't remember. But if they're doing a good job and they're reaching 2,500 children, you would want that entity to get some money. So you might, when you're doing your tally, and then it comes up that they got a score of 88 out of 100, you only have, I think at the time we didn't have $1.8 million. It seems to me it was more like 800,000 to disperse. The people who got, or the entities that got 95%, they might get 100% of what they asked for. If they were 88, they might get 95% of what they asked for. But as you did that, the monies that they were asking depletes the 800,000, so that by the time you got to 65, a ranking of 65 or 60, there was no more money. So people who didn't have a good grant application it didn't matter, And there was no discussion on the rankings.
You're describing your experience in the past.
That's what I thought I was walking into.
Where was that experience, at Metro Nashville Arts Commission or Tennessee Arts Commission?
I was on the
You were on
Tennessee, wait a minute. I was on the Tennessee Arts Commission. I had a full-time job. They asked for volunteers at the Tennessee Arts Commission to go over and participate in evaluating to see how it worked. I took a day off from work and I went over there.
Over to
Metro Arts Commission.
Metro Arts, okay.
The Metro Arts Commission had a room at the Howard School, if memory serves right, and there were about 17 people sitting, as you all are, in a much bigger room, all the way around. We introduced ourselves. I didn't know anybody. There was somebody from the General Jacksons, somebody from the William O. School of Music, somebody from TSU Art Department. These were all volunteers. I might mention, these were all volunteers. The complainant served as one of the evaluators of the grants, and she was paid $500 to do work that had previously been done by volunteers. That's also in some of the documents.
Is this 10 years ago?
No, this is recently.
Oh, recent?
She was paid. I volunteered 10, 15 years ago. Nobody paid me.
10 or 15 years ago, you were at Tennessee Arts Commission, and one of your tasks as a volunteer for that was to come and consult with Metro Arts
Just be a volunteer
for a
consultant.
day,
Yeah,
to kind of give them to consult with them about how to set things up.
Correct.
Okay.
No, to evaluate the grant applications.
To evaluate for Metro Arts.
Yes.
Okay, got it.
These people
Got it.
came in for
Okay.
one day, they did the grant application,
Okay.
review,
I see.
and then we dispersed and we never met again.
But the last time you were involved in that was maybe 10 years ago, until you,
Probably more.
more than that. This comment about the complainant, what time period are we talking about?
Last year.
Last year?
She was one of the individuals who did a grant review. If you look at the,
I see, the new way of doing it in Metro was to have it more
The director
community-based.
He paid people from the community to go out and do the grant reviews.
I see, okay. Do you have any follow-up questions as to that? Okay, all right. Hearing that there are no more questions and the cross-examination has been done, I think we are concluding the evidentiary portion, and now we'll just take very, very brief closing arguments to make the point.
I'm sorry, but she went on for a very long time. There were a lot of points that were made that need a response to.
Yeah, I think the procedure has something about a
sorry.
rebuttal case.
That's true. Yeah, so you have, it's true. You cross-examined, but a rebuttal case would be counter facts, right? It would be to present evidence that counters the respondent's factual case. And if you have a rebuttal evidence, we're happy to hear it.
Yeah, it does say after the respondent rests, the complainant may present rebuttal evidence in the mode set forth in section 4A.
Right, so clearly there's, yes, you're
That's
exactly,
your case in chief.
yes, you're
that kind of
exactly
Yeah.
right.
And I would suggest if it's evidence that you've already pointed to or alluded to, but you want to incorporate the rebuttal into your argument, I mean, I'm fine giving you the time you need to make your
For argument, but that's just but thank you, because that's very helpful to distinguish. A rebuttal case would be evidence that specifically contests facts just presented. If you have that, then you have an opportunity to provide that to us. If not, so you want to, there is no rebuttal case, factual, then we are ready to hear your closing argument.
I can't combine them.
Well, what are the facts? I mean, let's just do it formally, and we'll give you both opportunities. If there's-
I'm sorry. So just to be consistent,
Yeah.
if she's testifying to facts based on her knowledge, then it's not based on the documents that she submitted.
She would be sworn, she would be, yes. Do you have do you have facts to present to us that counter the facts just presented by a respondent? And if so, what is the nature of it?
That are not in the documents.
That are not in the documents, right? Like personal knowledge.
We do.
and then you could be sworn as a witness.
Okay.
Do you want?
Yeah, okay.
This is of your own knowledge, things you heard, saw, perceived personally,
Yeah.
that are facts that contradict or counter facts that were just presented.
My hesitation
Yeah.
is just that there's a lot of facts and there's a lot of information. So I would just rather do it with my interpretation of the documents, if that makes sense, keeping in mind what she has said. That's just because I don't want to jumble up things and.
Okay, that's fine. So I think what you're saying is you do not want to present a rebuttal case, but you want to address what she said in your closing argument.
Yes. And I'm fine being sworn in. That's just,
Yeah.
yeah.
I think to be safe,
Okay.
it doesn't hurt to
Swear her in, okay.
Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
I do.
And just for completeness, everything you said earlier today, are you willing to make all those representations under oath? Yes, okay. That seemed like the
That's
most
good.
prudent
That's
way to
good.
deal with it.
So I do also want to say that there were several artists and staff members at Metro Arts that I reached out to be witnesses for this, and out of fear of retaliation, given what happened with the Will Cheek case, that they feel they don't want to come out and put their name on something that possibly a commissioner with ties to the large organizations that the public is perceiving has ties to the large organizations could come after them, or the large organizations could come after them. And they were willing to do something anonymously as well with this board, if that is something important. I want to clarify.
So no one else has been present or shown up. I know you use "we" in your complaints and so forth and all your materials, but there is no one else. I mean, you are the sole complainant here, and this idea of,
Well, yes, so there are people who are willing to testify to what I'm going to say, and a lot of the evidence here about like what happened in November, what happened in February. But
they would corroborate what you're saying, so
or
it's
what's
unnecessary
going
for
on
them.
with
Okay.
staff in the background.
Okay.
Yes.
But I just, yeah.
I just want
From your
everyone to be
own
aware.
personal knowledge.
Yes. What was happening during the vote in August, so McCoy characterizes it as that there were promises made. And I do want to say that this has been decades of work, predominantly by women of color and Black women, who have worked to make this department equitable. So what McCoy was referring to in the beginning was the grant selection process. Because there was a public sense that the Arts Commission was not being equitable years and years ago, the community, Metro Arts staff decided, and commission at the time, decided to establish a grant selection panel made from the community. What would happen, so these selection panels, you come in, you read applications for 4 hours, and then you come in and spend 4 hours of your day reviewing it with other panelists. So it's a total of 8 hours of a lot of reading and a lot of commentary, and you can imagine predominantly the people who would show up, who would have a 9 to 12 p.m. slot on a given Thursday. That was predominantly white people, and predominantly what was happening with these applications, and the ones who were being chosen and the ones who were being denied, you can imagine. And so there was an effort within Metro Arts decades ago to make sure that this was equitable. And so community members like myself could come in. I have a full-time job, but I was willing to come in and see what was going in with the grant selection panel, and to be paid for that labor. Because it is labor, and to make sure that people of color were voiced and had an opinion and could actually critique the question of equity within these applications. I think her attack on that type of initiative shows that these are equitable systems that people of color have fought for decades that a commissioner can come in and simply take down. And I'm going to get to that as well in documents. And come in and make a rebuttal that is inaccurate of several dozen community members coming in and trying to make a system that is equitable. I also forgot to add to the material the Dana Parsons video. I think that it's pretty clear. I think that everybody in that room who was giving public comments, both in July and August, the council members who came through, the equitable grant makers who came through and spoke to the commission and said this is a very clear choice. Complexity is the refuge of the powerful. There is nothing complicated, there's nothing muddy about this. Many people came through. Dana Parsons had a full video. I remember Director Daniel Singh speaking at the August meeting saying, I had a meeting with each one of you. This is how invested he was to make sure small organizations and individual artists were not thrown under the bus year in and year out. So to me, the argument that there was confusion, I didn't know what was going on, is unacceptable for a commissioner, especially when there were so many resources at that time. And what's really important about the Dana Parsons video, and I wish I had added it, there is someone from the art monopolies, I forget who, but one of the representatives who says, isn't this, and this video was, I think, from April 2023, maybe April, May, who says, isn't it illegal to fund Thrive? So we know, and I'm going to present more evidence.
So, no, we're actually
Yes.
we're in closing argument now. You
I
had
know.
your case. We've gone through the evidence. So again, focus your argument, your closing argument, on why the facts presented before us by a preponderance of the evidence, which just means more likely than not, constitutes that ethics violation under the code, undue influence.
Yeah.
We have actually
I know,
spent an enormous amount of time on this, and it's really time to narrowly focus us on your best closing argument that there was an ethical violation here from this respondent, okay?
I'm trying to also offer a rebuttal because it's just unfair for me to hear all of this and not be able to at least offer a perspective. So I know, I'm also very aware of time. I got things to do. I know. I apologize, but this is important to get on the record. Yeah, so someone from the art monopolies also asked at that time very early on whether or not it is legal to fund Thrive. And I think this is very important because there are conversations going on at the art monopolies that community members like myself are not privy to, that were happening very early on before this vote, and to stop this vote. So.
The August vote or the February 15th vote? Which vote? The August 23rd?
So both the July and August.
Okay, those votes, okay.
Yes. My last rebuttal point will be that the commissioners who left were mostly the ones who voted for equity. And they left because, so the commission chair, Diana Perez, Ellen Angelico, Clarence Edwards, they left mostly because of what happened in August. So, and how disastrous this vote was. So I want to name that. We can't get these facts mixed up and muddied to serve another case when it is very clear from the MHRC report where their heart was and what happened when the other commissioners voted against it. I will also say there was another, in terms of the MHRC report where we have her nomination interview, it is also important that she is mirroring the language of a director of an art monopoly who spoke to me and said, I don't think these people would know what to do with $20,000, which is what the amount was raised to, is the $20K. And so for me, that type of language mirrors her quote from her interview in 2023. Their application was woefully poor. You wouldn't award someone or anyone that money until you thought it would be handled properly. The other interpretations that I would like to offer also come from the MHRC report. I want to emphasize that she did not listen to the council and the people of color. There were 2 hours of public comments during that time, and she's basing her decision, she says, solely on the code, and then she mentioned Jim Schmidt, who was the commissioner, who, from my reading of it, led the charge to when the firing of 2 Black women and a woman of color was happening in 2021. I also want to make sure that we are aware that she's claiming confusion, but she also, during the grants committee, was very strong against speaking about equity and refused to listen to the director, the commission chair, Mattia Powell, who also resigned right after this vote, and the community members. So it is interesting that in her in her testimony that she says there's a lot of anxiety for someone at the Tennessee Repertoire Theater. It's very important that a lot of the public comments during August were speaking about community members who had never received arts funding and would have to get their programming canceled completely. And that was an opinion she did not care about. And I've spoken multiple times in front of the commission about how that vote has impacted our organization. And that is someone she does not care about, versus we have multiple public comments have come out and said people who are at the Tennessee Repertoire Theater have a full grant-making team. As far as I'm aware, they have fundraising staff, they have a lot of donation pools that they can apply to, versus an independent artist. I don't have a grant-making team, I don't have a fundraising team. And what that means in a time of scarcity, who we're prioritizing. And Director Daniel Singh and Director Mattia Powell both mentioned the metaphor of the triaging. So the situation at hand in August, to be very clear, was yes, there was not enough money for everyone, but where are we going to put the money? That was the problem at hand. So the problem was not, we made promises to white people, to these white organizations. The problem was, in a time of scarcity, are we going to give it to the person bleeding out or someone with a headache? And that was the vote in August. Towards the second accusation about February, I also let me also mention about Jim Schmidt as well.
Okay, use your. We're going to just do a couple more minutes.
Okay.
Couple more minutes. So use it wisely.
Okay. Her conduct is unlike most commissioners, even conservative ones like Jim Schmidt, who led the firing of 3 women of color. He was the chair at the time when that was happening. Even he voted for equity in July. So to me, her conduct is not one of like someone who's conservative or liberal or, you know, however you want to frame that, but rather someone who is on a mission who is giving cues and scripts, whether from a higher government official or from other commissioners like Cheek or otherwise. And this gives the impression to the public of undue influence, that she wasn't even able to vote for equity in July. In February, I want to focus on the February 15th and the dubious claims that she made. One, she claims that Thrive is self-reporting. The general operating grants are also self-reporting, but because those are predominantly white, there's no issue with them. But there's an issue with Thrive recipients self-reporting.
The operating, aren't they audited?
I'm not
So I understand that
sure.
operating are audited, Thrive are not audited. So that's a distinction.
I'm not sure, but from what I hear I have friends who are in the general operating world, that they do self-report at the end before that could be an obligation to apply to the grant, but the self-reporting at the end is pretty similar to what Thrive recipients do.
Which is
From
also
my
typical
understanding.
of any grant recipient.
Yes.
In any grant program, if you receive a grant, you self-report on what
Yes.
you did with that money.
Right, and then it's reviewed, and maybe that's what they call the audit, to confirm.
Well, the audit is different. Some grant programs require the organization to submit an audit, a general operating audit of their organization that's not tied to how they use that money, but the organization's finances. So the audit is separate from the grant reporting
Right,
process.
right.
In typical situations. I'm
Right.
not speaking to
Right, but we're distinguishing the, operating grants from the Thrive.
So just to show that people of color have one standard, white organizations have another standard. She also claims the grant selection process is dubious, and she paints this picture of dysfunction and mistrust. A lot of the grant selection panelists are people of color who want to know where the money is being spent and who have backgrounds in equity and can judge whether an applicant is being equitable or not. And so she paints this picture of dysfunction over processes that have been happening for decades. She has disagreements about paying grant selection panelists. To the point now, the last grants committee meeting, they are moving that power back to the commission. There is a plan in motion to deny a lot of our community members the opportunity to look at these grants, see who's getting funded, and it's moving back up to the commission. So we're already seeing the rollback of so many decades of people of color advocating for equity work. A lot of this is coming in because of conversations between Carol McCoy and the new grants manager, Sydney Davis, which is...
So, like, right, that is not from your personal knowledge, right?
No, that's what I'm being told.
It's okay. Well, this becomes, very hearsay-ish. I mean, you really, 2 more minutes, and then we're going to finish this. 2 more minutes, and
Okay, and I'll say that was something that they were advocating. Cheek and McCoy were both advocating for the power of the commission to be taken back from the community, both in October and November commission meetings. Her other argument during this meeting and now is that there isn't enough money. This is not true. Metro Arts last year received an increase of funds, and also this year. And this also ignores what community members have been saying, that the issue is not an increase, but rather in scarcity, who are we going to support? She will argue that February 15th she had to fire Dana Parsons, even though this person came through a bidding system and was well-liked within the community.
I'm going to stop you there, and because that's a characterization. I want to get the facts in. She moved to have the Dana Parsons contract terminated. It was seconded by another commissioner, is that true? And
Yes.
then there was a vote by the commission?
Yes.
Okay.
But this was,
And I understand you're saying she moved, and that's your
she
point.
derailed the meeting, so that was
But it
not
just-
on the agenda.
Okay, but I just want the facts to be clear for board members.
Yeah, sure. Yeah. So the community didn't have time to even hear about what they were going to do with Dana Parsons. And this has led
Wrap up
to, the
I'm
cutting
sorry,
off,
Madam Chair, you just took 30 seconds of her 2 minutes.
Okay.
And I don't think we should be setting time limits on the fly. I have a problem. If
Okay,
we're not going to
that's
set
fine.
them prospectively,
That's fine.
then I
That's
think we
fine.
need to give people the latitude to make their case.
That's fine.
Now, I'd be happy
I do think
to set
that
them
we are
prospectively.
almost 2 hours in, and I don't know that we've ever had a hearing.
Well, obviously, this
But-
hearing touches on a lot of thorny issues.
Absolutely,
And I would be
and
happy
that's
at the
fine.
beginning of our hearings to say, here are the time limits, but I don't think we can do it on the fly.
That's fine, and I respect that position and that view. So how much,
How much more time do you need?
I'm really wrapping up, so
Okay.
like the 3 minutes,
Please
hopefully.
wrap up.
Not
Okay,
more
thank
than
you.
5 minutes. Okay. So she says that this is fiscally irresponsible to cut off these consultants, but what this has done effectively is that right after cutting off the consultants who were in charge of training the new Metro Arts staff, they were not fully staffed in 2023. They are finally fully staffed at the beginning of this year in 2024. There's no training and there's no institutional memory that's being passed on. So now we have the situation where because of this sense of we need fiscal responsibility to not be, to be an understaffed department and then to pay consultants to help the department through the grants process, and then to immediately fire these consultants before they can train new staff. And these consultants were known for their anti-racist work. We then have a problem with Metro Art staff who don't know what to do with the budget season through February and March and didn't know how to go through the grants process. So now we have a full grants process that has been fully halted, and then we have accusations of Thrive being illegal, even though this is an interpretation by the finance department. Thrive goes through the same procedures that any bidding process, similar bidding process that most people asking for procurement funds go through. And so this has led to actually a burden to not only the staff, but also to the community and the anxiety that we are not going to have Thrive exist this year, all because there was a commissioner who derailed the February 15th meeting, spoke about something not on the agenda, did not give community members the time to do public comment and to speak about Dana Parsons and Justin Lane. And at that time, too, cultural planning was also halted completely. So, in closing, I just want to remind us about the impact that this is going to have, that your vote is going to have, or not your vote, but your discussion here today is going to have on the arts community and how other commissioners feel that they can act towards community members and what liberties they can take, and with staff and communicating with with only certain people within the community, and to deny us our space and the necessary moves that we need for equity in the arts. And I believe that McCoy has given the impression by her conduct, by her language, by who she's speaking to, that she is unduly affected by people of rank within the Metro departments and not impacted to make the whole decision about equity in Metro Arts from other departments, and that she has collaborated with them to destroy equitable measures and to halt the grants process and further provide or bring in the dysfunction of Metro Arts. Just end there. There are questions.
I'm sorry, I have a...
Yes, absolutely.
So the question that I asked earlier about the status of Thrive, is it your position that it's legal, it's fine for Metro Arts Commission to give grants to individuals as opposed to organizations? Is that allowed?
So, obviously not a legal expert. From what I am understanding, from what I've read from the procurement code and from what I've heard from other people within Metro, that Thrive was brought on in 2024 to speak to a need of a lot of individuals who are not being funded and not being allowed into white spaces.
You mean 2014?
2014.
Oh, sorry. Okay. And so how that process goes is that they file an application with Metro, and that application is put through a bidding process or a grant selection. So, and through that bidding process, they have scores and they have justifications for accepting this application, and which goes through like the procurement code of the very similar to the bidding process. And what happens then is that their artwork is then public. So I think the issue for people like McCoy is that they want to complicate it and say that art needs to be owned by the states. And the way it was interpreted in 2014 is that someone who's doing a workshop, a pottery workshop for the community, that is, because they're doing it for free and because they're being paid, that is owned by the community. So they see it as something more of something tangible like a statue, but there isn't, I think, room for interpretation to apply this to the art scene as something, you see someone who's singing, you see an open mic event, and it's accessible to community members who otherwise could not pay a ticket or they can't go downtown.
Okay, thank you.
I have a question. Do you have any knowledge of what the respondent said about the $700,000 that was taken from grant money to go to consultants?
Yes, so there was a special session on February 26th with the Arts Committee. Actually, Councilmember Joy Stiles is here. And Director Daniel Singh said that because he was understaffed and HR blocked him from hiring anyone for that fiscal year 2023, they told him to wait. He moved those line items, to the best of my knowledge, so that he can be fully staffed and he could run the department. With 6 people, he could not do that with a department that required 15. So, and it ended up, the department was not in a deficit, that he kept the department floating, and that's what he needed to do to make sure that the funds were getting to the community.
But they were coming from grant money that would go to artists and went to consultants instead.
I think the issue with that argument too is coming from someone who defunded the artists.
I'm just factually trying to figure out what happened, and I know you can't speak because you're not listed as a witness. I know you want to, but I don't think you can. But anyway, if you don't have factual knowledge, that's fine. I was just.
I also don't think that this is an ethics complaint against Daniel Singh. That this was about the commissioner's decisions and active choices about who she engaged with, who she chose to believe, who she chose to feel their feelings. Every single time we have this discussion about Metro Arts, it always comes back to one scapegoat, his finances, the way he made his decisions, and we're not interrogating the other actors.
Any other questions? Do you need a minute? So you're reviewing it.
No, I'm good. I'm just looking at procedures. I don't have any questions.
Okay.
Thank you.
I have a general question, just in general. Are there ever any circumstances where there's information where a council member can provide procedure information?
There is. There
There is an exception to the witness list.
Yes, that's what I'm
here.
saying. We can
that I
decide,
read.
I've got it, we can decide to take a statement from anyone, even if they weren't on a witness list.
Okay.
We have the discretion.
Right.
To do that. Would let's see, Ms. Carpenter, you asked the question, and there's some indication that she can answer it. Do you wish to put her under
Well,
oath?
I mean, I want to look at the rule. And
Yeah, it's
it says,
2A4.
Yeah, or 5.
5.
I mean, it says in the board's judgment, there was good cause for not timely naming the witness and the other parties would not be unduly prejudiced. So there's actually conditions on it. I'm not saying that we have to be overly formal, but.
I would say that in this instance, because the respondent brought up this fact, the complainant wouldn't have known to name this witness to answer to that allegation from the respondent, and so I don't
So you
think
would like to
respondent
hear-
would be
That's fine.
unduly prejudiced since she brought it up.
So you would like to hear,
I would just point out that under 2A7, it says the board may, in the exercise of its discretion, permit interested persons present at the hearing to offer testimony under oath, even if those persons were not called as witnesses by any party. So
That's the
what I
one
just-
probably that makes more
that's what I
sense.
just
Yeah,
said.
that's what you were pointing out.
That works too.
Okay.
But there's no good cause on that one.
Yeah, I think it's fine. I mean, I don't.
Would you like to answer the question? Do you want to, I don't know if you need to be sworn with for form, why don't we
I have
just
to go
swear
over
you?
there, can I say it from here?
I do think you need to be sworn because it says testimony under
Yeah, it
oath.
says testimony under oath.
I have to get in the hot seat, not like I'm not gonna be in it in 2 seconds, but okay. All right,
He will swear.
awesome sauce.
Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Yes. The answer to your question, Commissioner Carpenter, is during the specially called meeting, I am also the chair of the Arts, Parks, Library, and Entertainment Committee. So I called a meeting to deal with all of these issues. This is just a segment of the issues. In that meeting, Director Singh did share how he was using salary savings to pay for contractors. I would like to tell you, I've been involved in the Metro Arts debacle since 2021. And that was when 3 employees came forth with racial discrimination claims. This department was on fire when Mr. Singh was hired. And during that time, I will say, to his credit, he created a new application period that went from 22 applicants to 131 last year, because he differentiated between those organizations that had operating over 500,000 and those that had operating budgets under 500,000. So this is kind of where it opens up how we're kind of trying to distribute funding equitably. to several points that were made today, commissioners after the August vote, some termed out and some stepped down. If you read the MHRC report, they are very clear. They stepped down because they were uncomfortable because Metro Legal had coerced them into redoing this vote. So you're down commissioners. Mr. Singh hired, I think, in the fall of '22. This was his first budget process last year. We as a council determined, because of his presentation to the Women's Caucus, which I am chair and was chair last year, as well as the Minority Caucus last year, former Director Singh had a plan for Metro Arts, which had never been presented to us in the past. It had been rinse and repeat. And so he came, he had 4 main tenets of the plan. Women's Caucus, there was something for women and children. There was something in terms of minority artists. It is how we came to the ultimate decision to give an additional $2 million to that department. The decision on behalf of Minority Caucus was, well, we're excited because here's a dedicated plan to give money to BIPOC organizations that have historically been left out. That was part of the contention when the money wasn't distributed. So,
When, just timeline.
Sure.
When was that? That was the $2 million that came.
The $2 million was what we voted on last June of 2023.
June 23, okay.
Now, here's where things get complicated. The $2 million that we determined to go to Metro Arts was not given on July 1 as traditional, right? This money was determined that it would come mid-year. It wouldn't come until January. So the confusion for Director Singh, because this was a new process for him in terms of budgeting, was understanding that that $2 million was not going to be available.
And was the $2 million contingent on kind of tax receipts or something? Was there any
No,
contingency?
we as a council
Okay.
had just determined we're giving extra $2 million
Okay.
because of the presentations that had been made, and when we did our budget Hunger Games, they got the $2 million. So with that, the funding wasn't available until January. I will not say that Director Singh did not make missteps. He did. This was one of them, is not understanding that this money was coming mid-year. So in determining the grants, all of the money wasn't present to be able to give the allocations. What that then created was just a waterfall of crazy, where it was, legal told him not to talk to anyone, not to talk to artists, so then artists thought that their money was being kept for them, but contracts had to be redone because this money was now not going to be available until January. So there was a lot of miscommunication, a lot of failure to communicate during this time, and a lot of blame laid at Director Singh's feet. Again, he hadn't even been here a year at this point. So there was no way for him to ruin an entire department. There wasn't a way for any of the things that had been laid at his feet to have taken place. And so I had a meeting in December where Director Singh presented, as did Director Davey Tucker from MHRC, because of the 6 complainants from the money that they were promised in July when the August vote took place. Those grants were taken away. So 6 people filed a complaint to say this is not fair, it's not equitable. MHRC subsequently did a report. Around the time that we were told in November by Director Crumbo that an audit was going to be called for, also narratives began about malfeasance from Director Singh. But as a council member, I can tell you, we had no evidence of any malfeasance whatsoever. And in fact, unfortunately you're not able to, but if you went and looked at the budget hearing for Metro Arts, which took place last month, Metro Legal and Finance showed up and said, sorry, that was our mistake. They're actually $45,000 in the black.
Let me ask you a question about that. I thought that the mayor added $3 million.
So if you look at the budget.
Yeah, I mean,
well,
it's a
so
little complicated, but.
it does get complicated because of how they moved money. So
Okay,
it's
but I'm
different.
So I just wanted to, it's true that did happen. The mayor did say, because it's a mess, he was gonna just add, and there was an allegation of a deficit, substantial deficit. I think the community heard the mayor say, we're gonna add $3 million so that everybody can get paid. The most they'd get.
So the
irrespective
determination
of the formula.
from,
But was that accurate, though? Is that understood? Did he add $3 million from somewhere else?
God, how to answer that question, because it's not as.
Yes or no,
okay.
it's not a yes or no.
Well,
It's not wrong, but it's complicated.
there's, again, this is a kind of a gray thing, because you have to look at the budget and
Okay.
see how things were shifted, and it wasn't done.
Okay, we have to be careful
traditionally.
here, because you're right, this is a big issue for the city. We have become enormously educated about the issues of Metro Arts, but we have to remember why we're here. And we are not here to solve this problem for
Correct.
Metro Arts.
No,
I just
would
wanted
say
to
the
give context
helps.
is important.
Yes. Oh, absolutely,
Yes.
absolutely, and it's been very helpful, but I'm just saying, I don't want
sure.
now my question
Oh, yeah,
to
no, I just wanted to let you know.
expand.
Because as you were asking, you
Right.
wanted a black or white, and it's not black and white. It's
Yes,
much
or- I
like
thought
the
it was
rest
maybe
of this.
yes or no, but
It's
yes,
muddy.
got it, okay.
As Kyle, Austin smiles, because he knows it's been crazy.
Yeah.
So with that, what happened is the $2 million that we voted on didn't get allocated. It just started being allocated because of pressure from several of us, outside, inside, to make it happen, because there was a desire for it not to be distributed. So where we sit right now as pertains to this particular situation, I can say, commissioner-wise, this Metro Arts is the only department that has a commitment to equity in its mission statement. It's the only one. So to have all of these issues is kind of like, how are we having all these issues in the one department that's supposed to be committed to equity? You've heard reference to Commissioner Cheek. Commissioner Cheek is no longer on the commission because he didn't have a commitment to equity, and so other things ensued after that, but he's no longer on the commission. Why you all are here today is very similar to the same concern of being on a commission that has an equity commitment and then not doing that work.
So just to, on that point, isn't Metro Arts the only committee within, commission within the Metro that has substantial procurement authority? I thought that was the case.
I do not want to.
We don't give away money.
I don't want to misspeak, because I'll tell you, one of the things that we're doing right now is looking at all of our boards and commissions, because we've got higgledy-piggledy happening everywhere. And so what we are doing right now is having the conversation and looking at everything to say, who has these rights, who doesn't have these rights, the potential, all of that.
Okay.
Including Metro Legal's involvement in all of them,
Okay.
because that's been highly problematic.
Okay. All right, is there anything else that anyone wants to ask of this witness or council member?
Does that answer
Just
your
for
question in terms of
clarity.
salary savings and
Yes.
that, and being down staff?
I
And this is
appreciate
why
that context.
contractors were hired in the first
Yes,
place.
I appreciate that.
So that money wasn't taken from grants?
No, this was when he presented how he was paying for the contractors in the meeting. He stated, I was using salary savings to move those funds over so that I could hire people to do work. And what I can tell you is my conversation with Director Singh in regards to some of this, and why staff members, though hired on, had not been able to do some of the things that they were doing, was that because he was down staff and there were still deadlines to be met, he had been using the contractors to keep things moving while new staff members were still being trained. So he did not want to allow those new staff members to walk into something that they weren't ready for 100%.
So you've been very clear of the rationale, why he did it, why it was necessary, and how he explained it. We have this document that was presented to us as evidence, which suggests that they were coming out, that these, and I don't know if this is the same thing, but my understanding was the document that's before us on consulting and professional expenses is showing us the budget items, where it's coming from by GSD general, with the numbers, and it's showing other professional services and then management consulting. So
What I can tell you is during this process, several other things that have taken place.
And I think in the video that, we're very educated, we've watched a lot of videos, there was the budget director that said that this wasn't from savings from unfilled positions, FTEs, that this is literally just moving across budgets. Now, that's fine, and we don't have to get into that, but I just want it's connected with the question asked, and you explained, new year, a lot of transition.
Many changes
And
have taken
so there
place
was-
as a result of what has happened over the last year. It is, and I wanted to speak to this, the Thrive program that was started in 2014. We have underfunded this department for over 20 years. So what has happened in my direct conversations with staff, former staff, executive, former director, saying, is there was a kind of an understanding. We're gonna give you your $2. You do with your $2 what you want to do with it. We don't ask a lot of questions. So that's why there's a lack of institutional knowledge right now in the department. There wasn't a lot of reporting. Checks were sent, but there wasn't a lot of paperwork associated with that. All of that is going to be changing now. There was a lot of relationship basis. Oh, if you get along with so-and-so, then you'll be okay. But then if your relationship isn't okay, then you end up where we're sitting right now. Right now, the way the program is changing is that there's going to be accountability that didn't exist before in terms of finances. So this whole program shifts and it comes under regular reporting formatting, which it had not been. What the commission is doing right now is figuring out what that process will be so that Thrive artists and muralists can be paid in the future, so that perhaps it's a nonprofit that holds the funds, and then they'd make the determination, here's the allotment of funds that we're giving, here are the artists, these are how much money they are to be given, you hand it over to this organization merely sends the check, so it's not coming from us. So those are the conversations that are taking place right now.
And that would move it into compliance with the existing code.
Absolutely.
Okay.
Everything gets fixed, it's
Okay.
all in process right now.
Okay.
But it was a hot mess
Yes. Yeah.
last year.
Okay. Anything else? Any
No,
follow-up?
not for me.
Very good. Anything else? Anything else? Thank you so much.
Yep.
Delightful, see you in a bit.
Okay, that,
We still have the respondents' closing.
yes,
And I think if she wants to respond to
Yes.
anything that Councilmember Stiles said.
right. I mean, they were additional facts. Would you have the floor.
Mindful as you are that we're not here to adjudicate all of these public policy disputes.
Absolutely not, no.
I came because somebody filed a complaint against me on the basis of my vote. That's a very simple issue. Nobody influenced me. My conduct has not been anything other than what I was appointed to do. That was to go to meetings and vote. I listened to what there was. I considered it. I made a vote. I didn't talk to other people about it. There's been a lot of innuendo and implication and characterization of who I am and what I am, and I have never had a conversation with the complainant. I don't know her. She doesn't know me. There's no merit to this, and I ask that you dismiss it, as I did in my motion. Thank you.
Okay, that closes the evidentiary portion. We can now move into deliberations, and I ask committee members to share any reactions or thoughts as we deliberate as how to proceed with this complaint.
Can I ask a question of Metro Legal? Something that came up very early in the hearing was whether a citizen has the right to make a FOIA request for somebody's private emails to the extent it relates to their official duties. I mean, if somebody uses their Gmail account to send emails about their board or commission work, are those public records? Does a citizen have the ability to do that?
Yes. I'm sorry, yes.
And
It's not FOIA for the record, it's the TPRA, but yes, if you conduct official business, even if it's not an official channel, those are public records.
So, just clear. So,
And may I say, conversely, if you're conducting private business, like, would you please pick up a gallon of milk? Even if that's through your Metro email account, that is not a public record.
And do we train board members on that?
Yes, perhaps not as frequently or as thoroughly as we should.
Okay. Thanks, that's helpful.
Discussion. So I'll tell you what I'm thinking. I'm thinking that certainly the presentation was comprehensive. We have an enormous amount of information about the issues, the Metro Arts issues, and so forth. I think the complainant summary of the material, again, very comprehensive and very cohesive in terms of the concerns raised by the complaint. I think it kind of pulls together all of the videos and reports and so forth and articulates a complaint. But I will say that there's some inconsistencies. The thing I'm having difficulty with that is that there is suggestions, characterizations of respondent as bias, as, I put a couple of things down, I think in a sense, we can understand the complainant's view that this particular commissioner is one of a few commissioners that did not seem to, in conduct and language and vote, act to be charging forward with an anti-racist, urgent anti-racist process. I think that is kind of what we're seeing, that this, she spoke to that issue, is it, the problem I'm having is from the beginning, this commissioner said, I care about like money and reporting, and these are tax dollars, right? No one has any, no one misses that point. These are tax dollars. So from the beginning, in her, and that's why it was very interesting to see her comments. She was appointed by Mayor Cooper, went before the Rules Committee, which is made up of Metro councilors, and she says, I care about standards, reporting, applications, and so forth. So, and then acts consistently that way through her tenure as a commissioner. So yes, the things, I do understand the complainant's points where she doesn't seem to be pushing forward the, the focus does not seem to be on equity. With the behaviors, the conducts that are presented to us. It does not seem equity above all else, equity first, equity urgent, equity meeting. It does sound like, given background experience, given what was stated in her application to sit on the board, she's saying, I think about money, I care about how we're using public dollars, and I care about standards and applications and so forth, meeting a certain level of standard. So the problem with this on the code front is that we have to show not only influence, but undue influence, excessive influence. And I don't see even influence. I think what I'm seeing through all this is I understand the complainant's perspective, and in that there was the group largely, essentially wanted to move fast and forward on equity and on a specific, well-thought-through anti-racist campaign. That's where they were going. And a commissioner is appointed, nominated and appointed, who comes in perhaps with priorities that do not reflect that. And again, not from the materials and from the argument, the very articulate position by complainant. But to get to an ethical violation, it's almost like it's an inconsistent argument, because I have heard, yes, the priority was how are we going to treat tax dollars? What is the reporting? What are the standards? How do we make sure that it's compliant with the code? If the focus was code compliance and all of that, then there's no influence at all, let alone undue influence. That's her views. So this is what I'm having trouble with, because she seems completely consistent with what her views are, that these are the things that are important, and while she might, and again, this isn't really before us, we have no idea what this commissioner's views are on equity, but I think I'm having trouble articulating an influence in her vote or her moving to terminate the complaint of Dana Parsons. I don't see the influence. I see her being consistent all through this. I don't see, this is not we don't have, as far as I see, and I'd be interested if anyone else sees it, I didn't see any evidence that she was waiting to hear back for whether she was going to get a position on the board of the ballet or the symphony or something, and that this was happening simultaneously, and she was being influenced to want the certain organization to be funded because it would benefit her or a family member in some way, understanding the limitations that's been discussed about gathering individuals' personal emails. But we only can deal with the information before us, and there's a preponderance of the evidence, which means more likely than not, 51%, just over. So that's what I'm struggling with. I might be missing something. There may be another way of looking at it, and I'd be open and interested to anyone else's views on this. That's the problem I'm having, finding undue influence.
I'll go unless somebody else wants to. I think that this board service on the Arts Commission is a hard, thankless job. It is time-consuming. There is not pay. And I think distributing arts funding is particularly difficult because people who are interested in doing that probably have connections to people in the arts community somehow or another. I'm also mindful, sometimes I sit here and stare at the Metro Council posters from the 60s, and it is almost exclusively men, and it is, there's racial integration very deliberately, but it's a city that does have a history of white control, and I'm very mindful of that. I think that Ms. Youssef and others have really raised some important systemic issues. I mean, there's a 45-year discussion about arts funding going on, about systemic racism and bias in the way funds are distributed. So I was all set to say, I think this is a public policy issue and not really an ethics issue, because you've got the Arts Commission making policy choices about distributing funds to organizations of different sizes, different racial makeups. There's a whole long conversation about equity and grant selection. You've got management and HR issues in the department that have been going on for a few years, at least allegedly. You've got allegations of financial impropriety and the finance department getting involved. You've got the Metro Human Relations Commission getting involved, and in some ways we have dueling reports kind of from the finance audit and the MHRC report. And so, there is this political process going on, and it has been very messy, but it's arguably working because you've got the Metro Council's attention, as Councilmember Stiles testified to. You've had the mayor's attention on this, and you've had the Arts Commission's attention. Obviously, the commission itself has been in flux in terms of its membership, but there is a public discussion going on about these issues, and there is a substitute budget and a process in place that Councilmember Stiles talked about. I also think, Ms. McCoy said she's a finance person and she makes decisions on a financial stewardship basis. That's a valid reason to do things. In my view, when I look at what we're charged with enforcing, board members can have unpopular opinions, They can resist efforts for equity if they want to, even if I disagree with them. They can say that they have a personal view that only large organizations should get funding. They can derail a meeting and make a motion, even if I think they shouldn't do that. They can listen to one Metro department and credit them more than they credit another Metro department. I don't think that those are presenting necessarily ethical issues. What they can't do is give reasonable basis by their conduct for the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties, or that they're unduly affected by the kinship, rank, position, or influence of any person. The complainant made some reference to an accusation 2, McCoy was unduly influenced by the finance director's rank and ignoring Metro Human Relations. To me, that is not the meaning of rank in that provision. I mean, these are competing Metro departments, and I don't find personally that one or the other enjoys, that rank really refers to that. That's my personal view. But I was troubled when I asked the question about if she had had communications with members of the community in the arts organization specifically, and there were 3 examples of ex parte communications. She said 2 of those on behalf of the Nashville Ballet and the Nashville Opera were just asking what's going on, and the 3rd one was, former Councilman Charlie Tigard, and this conversation about a mural involving Michael McBride, who is, a friend or at least an acquaintance of Ms. McCoy, who had coached her kids in sports. And then Ms. McCoy asked the director about funding for McBride, and I believe she testified, so we can get him some funding. And then the director didn't want to fund murals, so there was a policy disagreement there. But it did seem to me that she told us a story in which she was intervening on behalf of a specific project. Now, it's not exactly what was written in the complaint. It is consistent, I think, with the allegations in the complaint. And so I don't really know what to do with that. I was concerned by that testimony. And also in light of the fact that she wanted to know specifics about which organization got what. And she testified about the Children's Theater and how they should obviously get funding for certain reasons. And
I don't want to disagree, but I think that was an example when she was saying, if, for example, she was, I think, describing scoring and the number of individuals that year that are
Served.
Right, served, thank you. And she gave that as an example. If you're serving 2,500 children versus 15, that might affect your score. So
Sure.
She didn't say.
That's fine, and I take it in that spirit. I do think that the process is designed to sort of insulate commission members from knowing all those details, I think, and maybe deliberately so. But again, that's a public policy conversation. I think the question about having, communications with individuals in the arts community and interceding on their behalf, that is the one thing that really raised an issue for me against this backdrop and against the allegations here, which are larger and systemic and really, in many ways, I think, outside of the narrow purview of this commission. But I wanted to raise that testimony specifically.
And on the point about the muralist, I just again, because we all hear different things, and this is just check me on this. What I heard was that this is a person she knew, or no, I don't even know if she did know. She did know.
She said that
She
he
didn't know.
coached her children.
No, the artist did, but not the person
Art,
who
oh, the art,
contacted
right,
her.
he didn't know
No,
she didn't know the former.
The former
Did not
council
know
member
Tiger, right, sorry.
who called her because he wasn't able to reach the executive director, and that he'd been trying 6 times, I think she said, something like that. So that he reached out to anyone on the commission. My understanding of what she did was she just sent, I thought, an email or something to the director and said, FYI, someone's trying to reach you. And she didn't hear back. So that's what I heard. The follow-up was, I think they were literally in a meeting sitting next to each other, and she just said, did you get back to that person? I don't see that as intervening. Your description made it sound like much more like she was making something happen on behalf of someone that she had a relationship with. I didn't see it that way. It's true, there was the son and the counseling, but I think she passed along a message. Someone reached out to her. That's often what a person in a public service position would do. Someone calls. So I understand what you're saying, and I think it's valuable to review the facts that we've heard. I think it's really important. I heard it a little bit differently than you did, so I just wanted to get my things with it.
Yeah, I would say just on that point, it is, it sounds like the respondent got calls unsolicited from at least two of the people she knew. Yeah, when you look at the code section, it says, shall not give reasonable basis by their conduct for the impression. They called her unsolicited. I don't know that I can find that those calls meet the standard of her giving a reasonable basis by her conduct that these people could unduly affect her, or could influence her. So that, I don't know, I don't know what to do with it, really, like you, Mr. Spraggins. It's difficult. But aside from that, I would go back to the two accusations, because I don't think that's really related to what I think the core is, which is the vote, at least in the first one, on August 17th. So I don't know that those are related. I think maybe it was an example, and it was elicited from one of our board members in response to a question, but I don't know that it has an effect on the vote.
Yeah.
I just feel like if someone is improperly influencing someone, it's based, when I think of an influencer, it's someone that's influencing people based off their actions. So the things that they're doing and the things that they're saying. And this is really so great, because you can mindfully say something and it can affect other people and influence other people's votes or how they feel, or if they're going to decide to vote on giving people money or not. And according to these accusations, I feel like if you're derailing meetings and if you're doing other things that are improper behavior, then that can affect other people's vote. It can have an influence on other people. And so it just goes back to the code section. Is this happening? Is this what we're hearing? Are these accusations and are these facts that's going on during each time that they're bringing the accusations to the table?
I guess let me ask you a question, though. I read the code as saying that other people can improperly influence the board, the commission member, not that she is trying to improperly influence others.
And it sounds like it's been going both ways.
Okay, that's what you're saying. Okay.
I want to just make sure I'm understanding. So, and you're saying when people speak or act, they can always influence someone else that hears them one way or the other. Mm-hmm. Like influence is always possible. Mm-hmm. Is that kind of really what you're saying? Mm-hmm. Mm-hmm. Okay. Yeah, no, that's a very good point.
I'm really torn here. I see things a little differently, Chair Diani, from your initial remarks about your take on the situation and the fact that this commissioner has been acting consistently in terms of her priorities being focused on standards and financial stewardship and accountability or whatever it was. But in my mind, those words are often code for maintaining the status quo and being against equity. It's often used as these are the standards we've established. Who established those standards? When were they established? Who are they serving? So it doesn't persuade me that she has stated, I care about money, I care about finances, I care about these standards, because to me, that would then justify ignoring the community that you are being elected to serve on this Arts Commission because they may not have benefited historically from those standards or been a part in drafting those standards. So that doesn't cut the same way for me that it did for you. And so I'm really struggling with the code as it's written and the conduct that we're looking at, because it's really fuzzy. It's really hard to pin down the specific conduct. I know the conduct that's been alleged. It's the statements that the commissioner made in the meeting. It's the conversations that she had with others, and it's the vote that she ultimately made and the motion that she made to fire the consultant. That's the conduct, right? It's those statements, it's those actions that we're asked to look at to decide, was that conduct giving others a reasonable basis to form the impression that this commissioner could be improperly influenced or unduly enjoy their favor in the performance of their official duties. And in this instance, the official duties was deciding how this money should be dispersed, right?
The August vote.
Right.
And the consultant.
So I could see it going either way, really. Like, I could see if I'm a third party just observing this situation, and this commissioner has said, I don't think these types of organizations, call them small, call them, individuals, call them community artists, whatever. I don't think these organizations have the structure to handle the money that we are trying to give out. If I hear that, that's telling me she doesn't want to fund these types of organizations. And if I'm a larger organization and I have that structure in place, and I have, historically, gotten money from the Arts Commission, which is why I was really curious that she was really focused on the arts representatives coming into the meeting and saying, we were promised this money and we agreed to this new funding formula with the understanding that we would still get this money. Why does that matter? And I don't really feel satisfied in the response that, well, I didn't know, I wouldn't have made that promise, but you thought it was important to mention here in your testimony. And so that troubles me. I feel like there could be an appearance in the community, among the public, that this commissioner comes into these decisions with this slant towards maintaining the status quo.
Okay. So I want to just try to articulate better what I said before, because I think I might not have done it well. So I don't know that you and I have the difference that you just described, because I wasn't saying, so she cares about standards or what, that sounds good to me.
Right.
What I was saying, what I'm struggling with, and that's why I'm looking for others to comment on it. What I'm struggling with is this notion of undue influence by some other person or something. The undue influence, and what I was referring to was that, I wasn't referring to what her views were, structure, formula, maintain the status quo. I was saying, I wasn't seeing a change. I wasn't seeing this is how she came into it, and then this is I can't identify the influence. I know that the materials say it was, there was a staff person from, I'm sorry, I don't remember her name, Moyer or something, from finance. She came in one of the videos attached, and she describes procurement versus grant making. And so, the respondent said, I agree. Well, and that's, I think, one of the Metro staff people whose rank influenced her. Well, I didn't see that. That's what I'm saying. Because the view, I didn't see change. So that's all I was saying.
Right.
And help me understand, what is the influence? Now, if the influence is, what do we do with this? If the influence is status quo, I like status quo. My Rolodex has these organizations, that's the status quo. Bias, right?
Right. I don't read the code as requiring some sort of X then this happened and then why, to show the influence, because it's not that she needs to show that she changed her mind because of some outside influence. It's that by her conduct, she created the impression that any person can improperly influence her. Not that she has been influenced and therefore she voted a different way than she normally would have, but that by her conduct, she has given the impression that a person can improperly influence her. So that's different to me than saying this happened and then she did this.
How is her, how though is, if someone comes into it with is appointed and comes into it and says, you know, I think, let's say worst case scenario, I like the status quo, I don't buy this equity thing. Something like that, which would be highly offensive and contrary to all the 10 years of work that people have been working on. Let's say they say that. Are you saying that showing they could be influenced, improperly influenced?
Yeah, they can be improperly influenced because if they come in with this idea that these people are more deserving of the money, whoever these people are, however you define them, Group A is more deserving of the money. If that's made known publicly, then anybody in Group A feels like they can improperly influence her.
But she already believes it.
Right, but she's acting, if she's making that known, and then she's acting in accordance with that, then these people feel like they have this connection. They have this relationship that they can have with this commissioner by the fact that she's made it known that she favors them.
So maybe
it doesn't matter that she already favored them. Coming into the situation with this belief doesn't mean that there can't be improper influence. Is my reading.
Actually, and as I'm reading it, I think I was focusing on improper influence, but you might be focusing more, which is also there, in unduly enjoy.
Yeah.
Yes.
That's really, it's the unduly enjoy the favor. That's kind of what you're saying.
Yes.
Yeah, okay, I see that. I see what you're saying.
I also see what you're saying, and I think the biggest weasel word in all of law is the word reasonable, because it all depends on who's making the judgment. And, you know, there's a history associated with that too. For me, specifically to the conversation you all were just having, the fact that the allegations are really all centered on her official conduct. It's not her personal conduct. To me, that's what helps tip the balance, I think, in favor, and I'm thinking out loud, of saying that this is not the type of violation, or this is not a violation of Section K. I can imagine a lot of scenarios in which somebody's conduct, either through public statements or through going to lunch with people or having phone calls with people, gives the impression that certain folks can enjoy favor in the performance of their official duties. I think making statements in public meetings about, views on public policy effectively, even if they're views that I disagree with, I have a hard time bringing the ethics code into that type of conduct. So that's how I'm thinking of it at the moment.
Is that because it's not done in private? Like it's known, it's public information? Is that the distinction?
Yeah, and it's part of the deliberative process on the commission that she's serving on. I mean, I think if she went and gave a press conference in front of the courthouse and said, hey, big business, I'm your person, come see me, that would fall on the wrong side of the line to me. But the fact that in these conversations, she is articulating some, public policy concerns about grants versus contracts and things like that. Whether or not I agree with them, whether or not we do or don't think that it's code for other things, I do think that she's entitled, as part of her official duties, to raise these issues. And I think, again, I also come back to the fact that the political process is working in many ways, as we heard Councilmember Stiles say. Not to say that this was not a setback for the goals of equity or anything like that, but there are sort of higher authorities that can make these decisions, and that's the council and the council arts committee and the mayor and folks like that. So to me, the conduct that we see here giving this impression, it just does not, I don't think that it falls on the ethics violation side of the line.
Let me ask you a question. Probably Ms. Young. So, and again, I'm just struggling with the language of Section J as well. And it does have an or, so it's, to me, it's two different things. Shall not give the reasonable basis by their conduct for the impression that a person can unduly enjoy their favor in, or that they are unduly affected by their kinship, rank, position, or influence of any person. So, what is the factual basis for the idea that either the respondent, by her conduct, gave the impression of being somebody could unduly enjoy her favor, or she's unduly influenced? Is it just the vote? That's what I'm trying to, what the vote obviously was against the August vote, the more equitable. In addition, what are you thinking about?
I'm thinking about the statements that were made prior to the vote.
Okay.
And the conversations that were had, either during the hearing or during the meeting, or, outside. Again, we don't have any emails or, phone recordings or anything like that, but I thought that there had been, some mention of conversations happening outside the hearing that were then sort of repeated, or the sentiments were restated in the hearing, like calling into question the legality of the Thrive program. Like, even making those statements sort of could be interpreted by some as giving the impression that if you're not in that category, or that, people who are a part of the Thrive program are not going to get her favor, and people who are part of the established arts community who've traditionally been funded would enjoy her favor.
So if someone thought, when you read the procurement stuff, when you read the audit, and you look at how, and it was presented to us, how Thrive evolved from 2014, and it had, and you see from the audit report, and actually from our council members' testimony about what they're doing to bring it all into compliance with the code. If someone alerted to it, say, what? The code says we're supposed to be only giving it to two of these types of organizations. Thrive is not that. We see the history here, but it has exploded. It's no longer compliant, with the narrow exception that started in 2014. And the council's supposed to be approving it anyway. I mean, if you start looking at it from a legal perspective and saying, is that in and of itself anti-Thrive and bias against Thrive? If you start asking yourself the legal question, wait a minute, look, when you actually read the code, oops, it's evolved and no one was kind of paying attention to this. Maybe they could have annually been getting the procurement agent officer to approve the larger amounts and so forth and so on, or corrected it, changed the code, if council had done that. But it's just beginning to ask the question and say what we've been doing unintentionally. We're realizing now that we read the actual language of the code, oops, we haven't been following the code. Is that concern in and of itself anti-equity, or showing non-Thrive artists can get undue favor from you, expect undue favor? This is the problem I'm trying to figure out.
I'm glad you mentioned that, because one thing that I was sort of curious about is the timeline of this concern about the legality of the Thrive program. It didn't seem like there was any mention of that. The first time I saw that was in the affidavit that was attached to the motion to dismiss. I hadn't heard that concern before. It was more so these types of organizations don't have the accounting or the financial structure or the ability or whatever to handle this money. I didn't hear the concern about whether the Arts Commission could even award money to someone who wasn't an arts organization or a 501c3 until the affidavit came. And so it seemed a little, questionable to me if that was the true motivation at that point. Because until you have an audit, until you have someone look at the code and look at the Arts Commission's, charter to say what they can and can't do, where is the basis for saying these people aren't eligible to receive the money?
So in the complainant's documents, and there's so many things, and I know that none of us probably looked at every single page or every single video, but it was definitely I don't know, I don't have an answer. I don't know factually, if anyone here does know factually, when the first time they started talking about is Thrive compliant with Metro Code. I don't have that knowledge in my head in terms of all of the meetings and videotapes. I did look at an April 24 meeting where the finance staff person, Benton Moyer, definitely went through a description of procurement versus grant and how it had gotten kind of a little over time, a little bit increasingly over whack. I think the reason, and then you obviously have the audit, which speaks to that. I wonder, just sitting back and thinking about, well, why was it not a problem the last 9 years? Why did it become a problem now in the last year when there was this real focus on equity and changing the way we're going to do this? Then it becomes a problem, and it hadn't before. That's maybe a question to research, and I do think that with all of this stuff that was going on with this past grant cycle, there was a big shift, a big change in the numbers, so that it was a very intentional and very well thought through process of moving funds to Thrive. There's $2 million that council get with the intention that Thrive recipients will get the money. That was what was new, brand new. And when $2 million gets people's attention, and all this, and it's written up, and it's in the newspaper, and people are saying, look at this move towards equity, I think it's likely that the trigger for wait a minute, you're right, you can look at it from the perspective, it's people who don't want equity that are now going to raise the question, but you could also look at it with a less, you could also look at it as the reason the question got raised was because all of a sudden all this money was going into Thrive, and someone somewhere pulled out the code, or the procurement person said, So I understand the question, why now? But I think there was such a dramatic change, such an effective change in saying, no, we're going to rework this whole thing and go for equity in arts, that in and of itself triggered someone to look at the code and say, wait a minute, or the procurement laws, and say, is this even compliant? Am
I allowed or not? You can tell me no, but I want to ask the question if I'm allowed to or not. Because the statements you're making have answers. It's not rhetorical. Because the money that was given specifically was for equity and making sure that programming was done. So it's not about someone getting the code. It is literally that we upturned an apple cart.
No, I understand. That's not inconsistent. I didn't think that was inconsistent with what I said. It was a big change. I'm just saying that change in funding, very dramatic, well publicized. Someone went and looked at realized, okay, now we're talking about giving real money to Thrive, individual artists and so forth, and maybe, I don't know, there's a procurement staff here in Metro. I used to do procurement in a different life, and started saying, where are the components of this? And maybe, so
I'm just saying, you can look at it from the perspective of, it's only because it was for equity that the issue, that they looked again at the legality of it. You could have that, bring that frame, but there are other frames, it's just the amounts of money were so large that people looked at it, and when they looked at it, they said, this isn't in compliance. So if someone looks at it and says this isn't in compliance, and someone else says, what, it's not in compliance, particularly someone perhaps with a finance or law background or something, and attends to that and says this isn't to code, I just don't know that statements to that effect could constitute an ethical violation.
Well, the statements weren't to that effect, though. That's where I'm you know, on the fence. Like, I didn't read or see statements from the commissioner saying, I have concerns about giving money to these recipients because it's against the code or against the charter, or they're not arts organizations. It was more so, they don't know what to do with this money.
Oh.
That's different.
Right. That was presented, you're right, that was.
Correct.
So I think to find that that's an ethics violation, we have to find that that statement, which is, you know, maybe at the least paternalistic, it could be evidence of unconscious bias, white privilege, things like that. But we have to find that that is conduct that gives rise to an ethics violation, or to the reasonable impression that one group or another can enjoy. You know, let's let the law speak for itself. Mm-hmm. And to me, you know, I go back to in the initial complaint, well, first of all, in the material summary that the complainant gave us, you know, it talks about this, that, you know, McCoy's definition of equity is not meeting BIPOC where they're at, but forcing them into hours of grant writing classes, promoting white-centered goalposts, excluding any who cannot meet standards, although they're doing the work. You know, it's the disconcerting flag of someone unwilling to unlearn, to listen, and to build equitable practices in Nashville. And in the complaint, the complainant said, you know, there's no exact mention of anti-racism in Metro Code. This board has the opportunity to place into precedence that repeatedly racist, unapologetic commissioners, board members can be sanctioned. It would be a major step against white supremacy in Nashville. And I think I'm not comfortable reading into the language of the code so far that we go past the statements that somebody makes and we find that their motivations were improper. That, you know, we find that they displayed improper systemic bias or a privileged view of the world. So it may be that we think that, you know, Ms. McCoy is doing the job the way it was done 20 years ago or 30 years ago, not the way it should be done today. Do I think that we currently have the tool to call that an ethics violation in the absence of the Metro Council, one of whom, you know, at large sits on this commission and one of whom is here and testified today, giving us specific guidance and another prong that says something like, you know, evidence of racist motivations or systemic bias. I mean, they could write that into the code and we could enforce that subject to courts looking at that. I don't know that what we have in front of us today gives rise to an ethics violation of the code that we currently have.
I understand that, and we've talked about this before in the context of this and other complaints, that ethics doesn't mean moral. It doesn't mean anti-racist. Like, there are specific things that are set forth in the ethics code, and it doesn't mention racism or equity, as far as I know. But I think that there is still an opportunity. There's an opening. It's subject to interpretation. And I'm not trying to convince you otherwise, because I'm still struggling with whether it's an ethics violation too. But I don't think that we should be so prescriptive in, you know, what the words say, because again, we're dealing with a situation where the people who wrote this may not have even been imagining situations like this that would come up later on. Like, we're struggling as a country to really grapple with our history. and to try to make a difference and do things differently. And so if we're still going to be stuck in, this mind frame of, this is what the words say and this is what this is, then we're never going to make progress. And I do see your point that we do have the Metro Council that could rewrite the Code of Ethics. They could amend it. They could add some language to clarify that. But I don't think, absent that we still couldn't use what's before us to come to a conclusion about this conduct.
So the question, do we need ethical conduct to be somehow intentional versus the person expressing who they are? At some point, I think that's where if someone, when at the very beginning, this orientation toward, it says, again, right here, what Mr. Spragan just read, right from the beginning, she did not have the kind of right definition of equity. She was not meeting by, but she was from the description, characterized, not getting the issue. From the very beginning, she was gonna ask BIPOC folks to do more work than was appropriate, after all this stuff. The mayor appointed her, and Rules Committee, which is the council, members of the council, approved her. So was that where it was baked in the cake? That's the problem I'm having. I don't see volition. Mm-hmm. I don't see fault. I see where people do bring everyone brings perspectives. And yes, I agree with everything you're saying about how do we ever get change. Absolutely, I think they're really important. But I think it's that sense of, was it inevitable that when she was appointed and she just was herself, her views with her history, and was it going to end up in a violation because who she is?
I understand.
That's the danger, I think. I think that's my concern. This is where I get the idea of holding a line and parsing, then you just have status quo, but on the other side, I think you also have danger and risk of saying, certain people shouldn't sit on boards.
Right. That's my issue is, and I hear and appreciate that we don't know who wrote this or when, and it should be looked at. But I go back to we're the Board of Ethical Conduct. And so I really, because it's such a difficult question, I just keep going back to that ethical conduct, and was this unethical? Mm-hmm. And I don't think it means unethical conduct, but I think it is an extremely, your points have been very, very well articulated, and I'm still struggling. So because of that, I keep going back to, okay, we're the Board of Ethical Conduct. And based on what I see here, I don't think that I'm willing to give the language the latitude yet, because then I think we're on the road to, if we don't, at least for me personally, if I don't go by this, then I don't know
what's the
where
limiting,
we're
what's
going.
the limiting,
right, for
limiting
me, I guess
factor.
that's the way I'm leaning.
Any other thoughts? All this talking. Okay. Well, we've been at it for 3 hours, so I think we have.
Welcome to Metro.
I don't even look at my emails.
Brought a lot of thought and discussion and deliberations, and I think I'm going to entertain a motion. Would someone like to make a motion as to how to proceed?
I have a question. Given the fact that we just have quorum,
Yeah.
if there's an abstention from the vote, how would that affect the count?
I think it's 4, right?
You can still vote, if there's just one.
You only need 4, right, for an action. You only need 4 for an action. We have 5. We have 5.
Okay.
An abstention would allow the vote to go forward. It would be action by the board.
Okay.
Full action by the board.
Okay.
Okay, here. So would someone like to move? I guess not.
Well, I'm trying to figure, I will make a motion to find that based on the evidence presented by the complainant and the respondent, that the respondent's conduct does not violate, make a finding that the respondent's conduct does not violate section 2.222.020 subsection K.
Okay. May I have a second? Is there a second?
Second.
Okay, any additional discussion? Hearing none, we can take the vote.
Chair Diani,
Yes.
Ms. Carpenter,
Yes.
Ms. Grimes,
No.
Mr. Spraggins,
Yes.
Ms. Young.
Abstain.
So we do not have a action. There's a no. So it's 3 yes, 1 no, 1 abstain. So we do not have a decision on this. When that has happened in the past, we schedule a new hearing.
Oh.
Well, what other, so we have, I think Mr. Gutierrez won't, but he's recused himself anyway. Right.
And Councilman Suarez doesn't vote.
She's a non-voting
And then we
member.
have an absentee from the Central Labor Council's not yet appointed someone. That's
So
a
maybe,
missing.
does this have to wait until we have somebody that can?
Can cast that fourth vote.
Or not?
Or
I mean, if they don't
people
vote.
sometimes come back and change their votes.
Right,
That's happened as
sure.
well. We've just had we've done the hearing day again, and people have changed their votes. So, let's not, yes, that's an unknown, we're gonna have to schedule it. So, okay, so we do not have a decision on this. The vote is recorded in the minutes. We will not be able to issue an order. The complaint remains pending. We will reschedule another hearing day.
Can you just point me to the 4 vote requirement? Is it in the hearing procedures?
It's in the code.
It's in the,
It is,
I see one reference to it, but that's with respect to the sanction. So I'm just trying to make sure.
action of the board, and I had to flip back to find that. This is subsection 3A.
Okay, I see it now, thank you.
so I'll just ask counsel of it. We have, it's my.
I'm sorry, I got it.
Yeah,
So-
yeah.
So 3A is talking about the sanction. It says, if after a hearing, the board decides that a metropolitan government elected official violated the standards of conduct, then the board shall take one or more of the following actions as decided by affirmative vote of at least 4 of its members.
I don't disagree. I'm sort of relying on the chair for the way you've interpreted that in the past.
We have taken, so, we used to be a quorum of 4, and then our board got expanded and added 2 members. And when that happened, we specifically asked that quorum would, I'm gonna turn to our board secretary here. We have, in the past, been told that it's 4. The quorum changed to 5 when we went to 7. They were gonna make it 6, and I requested they don't make it 6, they stick with 5. And so that's our quorum requirement, and our ex parte, our ex officio member counts for quorum. But that there wasn't going to be a change on our action, that 4 would remain the same. It had been 4, and when they expanded us, they didn't change that. We still could take action with 4. That's certainly the way we've been proceeding this year, that 4 constitutes the vote.
I found it. It's in there. It says any decision shall require the affirmative vote of at least 4 members of the board.
So, given that, and given the vote, I want to make sure with legal, there's no other option I'm missing other than to reschedule this hearing.
Unless someone else wants to make another motion that receives the 4 affirmative votes.
Someone want to make another motion? You mean to, for instance,
Somebody could rephrase it, or you could.
I see, I'll make another motion, okay. I see, we could make another motion with respect to this matter
That's true.
and revote. And we could, for instance, we could make a motion that we find that the conduct raised by the complainant raises concerns that the commissioner did not sufficiently prioritize equity in the performance of her duties. However, we find no basis, in fact, that any ethical violation was committed, including, and not limited to, Section K. So I think the suggestion was something along those lines. The effect of that would be the record, it'd be in the record, public record, forever posted. It would be a finding of no ethical violation, which is how it'd be captioned, and the complaint would be resolved and dismissed at that point. There'd be no pending complaint. That would be another way. Now, is there any reason to make that motion? Okay, I make that motion. Is there a second on that motion? Wordsmithing to be accomplished by the group. Does anyone want to second that motion?
I mean, I'll second for purposes of discussion.
Okay, so any words along those lines, would that?
So just to make sure I'm clear, subject to wordsmithing, we're essentially putting in the record that we find, based on the evidence, that the commissioner's conduct was not equitable, did not prioritize equity, is anti-equity, whatever the words are, but that's not an ethics violation. That's essentially.
It could be the evidence, yes. So we would wordsmith it. And we'd have to be clear about the wordsmithing. I mean, we'd want to be, we'd have to agree on the wordsmithing. It would be along the lines, kind of saying, we kind of understand where the complainant's coming from. I mean, but the concerns raised by the complainant, while we understand them as a board, and in light of the effort over many years to pursue equity as a priority, that while we understand the concerns, the facts do not present proponents of the evidence that there's been an ethical violation. So that's the concept. I know, and I know there's some very good wordsmithers on this board, so I will look to the wordsmithers. Or, Michelle, is there a language that?
I'm not hung up on the language. I'm hung up on whether that would then allow for a clear statement that going forward, the Board of Ethical Conduct is not going to be deciding anything is unethical if it is just anti-equity. You know, like it creates a line in the sand. Like equity isn't in the Ethical Conduct Board.
Yeah, I'd almost be concerned of creating more ambiguity with a statement like that.
Okay. Yeah. Okay.
That's what I'm saying.
Right. I mean, I think you and I agree on that. That
Okay.
I don't know. I think
The other approach we could take is to, if we are dismissing this complaint, pair that with some sort of communication to the council about the issues raised here, which, as we currently understand the code, we don't find that they give rise to a violation or something like that.
Well, I think if Councilperson Swarner was here, she would be really a good communicator for that. Well, not that you're not, but she's in her.
No offense, I understood.
No, I'm sorry. I mean, that she's in her official capacity.
But that we have this lovely meeting, which is being tweeted and screenshotted all over the place currently. Yes, because this is a hot topic still on the streets. So again, to my point earlier, boards and commissions are having a very strong conversation, and I can tell you everything that I've heard just now. We need to update this code, and it'll be something that'll be on the docket to get done. Because, I mean, in general, I have several issues with this whole process. But I think we're seeing everything live and direct of what the needs are. So it's not going to be ambiguous for much longer.
So, but I agree with your comment about the language could get very sticky, and sending it to council could get very sticky, and I'm not sure that would be fair to the respondent, to tell you the truth. To send to council that we have problems with the conduct. I mean, it gets very, the thing is, we're at this moment in history, and we have to decide. A complaint has been filed against a sitting commissioner. We have to decide that now, or reschedule for a second. I guess we've decided it. We have to reschedule. I think I like the suggestion from legal that if we found language that we could re-vote if everyone were comfortable. But as we attempted to imagine that, we realize it creates other problems. So I think we are where we are.
Just a parliamentary inquiry. If somebody who did not vote yes on the original motion moved to reconsider that motion, is that allowed?
Yes. A
Somebody
motion
didn't
to
vote yes.
Motion to reconsider generally has to be made by somebody who voted in the affirmative.
Okay. Wow.
Who voted in favor of the motion that didn't receive a.
Oh, I see.
And then they want to change their mind.
Right. Do they have to change their mind after that?
Yes.
Oh, so are you making a motion?
I mean, it's just a motion to re-vote on what we considered earlier to see if this conversation has changed any people's votes. And if not, that's fine. We'll come back and do another hearing.
I will
It's totally
second
fine.
that motion. Okay, discussion on that motion?
I'm just confused.
Well,
Okay, so it's
There was
just,
a motion on the table, actually, that we probably should have done.
hadn't voted on
Yeah,
it.
that's right.
okay.
What was the motion on the table?
My notes were just, check the video, it was like a long drawn out.
The one about wordsmithing.
Oh, sorry, that's right,
finding the
okay,
problem
that's right, that was on the
with
table, we had
probably
seconded that, and
We can vote on that.
we can vote on
You
that.
can vote or withdraw the motion.
I will withdraw the
Okay.
motion. I'm withdrawing the motion, so we don't have to vote. And now we have a new motion. What is your motion?
I moved to reconsider the prior vote, which failed for lack of 4 votes, and that was to find no ethics violation under the facts presented by the complainant, specifically with respect to Section K of the Ethics Code.
I second that motion. Is there discussion on this motion? No discussion?
Is the effect of the motion to reconsider that we're actually we're voting on the merits of it, or are we voting on whether or not to reconsider?
We're voting on whether to reconsider. Okay, now let's take a vote on this motion to reconsider.
Chair Diani?
Yes.
Ms. Carpenter?
Yes.
Ms. Grimes?
Wait,
It's a motion for us to reconsider the vote we just took. So if you say yes to this, then we re-vote. If you say no to it,
we can revote, yes.
okay.
Mr. Sprague?
We have
Yes.
most in this house.
Ms. Young?
Yes.
Okay, so 5 yes votes, your motion carries. We are now going to vote to reconsider the vote we took on the McCoy complaint. That's what we are doing now.
But somebody needs to make that motion.
Yes,
You're just about to
no, I understand. I just wanted to clarify that that's where we are, and now we have to make that.
You can do that. You don't have to do that. You've sort of cleared the slate at this point. Somebody needs to make a new motion, whatever it may be.
Oh, so you're saying at this point, because our motion to reconsider just passed,
we no longer have action? Is that what you're saying?
If you're going to take some action, somebody needs to make a new motion.
Yes.
But it doesn't
Understand.
have to be the same motion that was
Right.
previously
Right.
made.
That's right. But the effect of this last motion wipes out, in a sense,
Yes.
our prior action.
Yes.
Okay, is there a new motion for action on this complaint?
Unless somebody else wants to make a motion, I will renew Ms. Carpenter's motion from earlier that the complaint be dismissed on the facts presented today.
I will second that motion. Any further discussion? Hearing none, I will ask Board Secretary to take the vote.
Chair Diani,
Yes.
Ms. Carpenter,
Yes.
Ms. Grimes,
Yes.
Mr. Spraggins,
Yes.
Ms. Young.
Abstain.
Okay. So the result is,
4 in favor and 1 abstention.
okay, so that was the 5. So that motion carries. That is action of this board with a vote of 4. And the action we've just taken is to find that there was not an ethical violation. We did not find evidence of an ethical violation under our standard of conduct, and the complaint will therefore be resolved and dismissed. There will be orders to that effect. Each of you will get an order to that effect within a few days, I think this week. And this matter will be resolved. It will be ordered. The case will be posted on our website. Okay. It is now 12:30, so that's 3.5 hours, and we have another case we're about to, and I do want to allow, and I apologize.
It will be way faster than
Yeah, it'll be way
this.
faster, but I do want to take a break in case folks need a break. So how about, let's say, 10-minute break? Okay, so we'll reconvene at 1:45.
Oh, it is, because, I mean, it's.
Prefer to have it out. It is so hot. Did anybody else have that?
Man, I had a question
I got
for you
real
and
hot.
you just scurried.
You got hot? Did you get hot?
I'm okay.
Okay, well, it'll come back to me.
Okay.
I'll
You
call
got
you.
hot.
Yeah, exactly. I know where you are.
See you later.
I like your blazer.
Very much. I'm gonna say it's like sixth grade or something. It really
Delightful.
Did you get anything else? I got everything. Yeah, that's great.
Classics, important. Classics.
Okay, got everything? Okay, we are back on the agenda. And we'll move to agenda item number 6, hearing of complaint, Griswold v. Councilmember Joy Stiles. We have the material before us that was provided to us by the parties, and the parties are here. Do we have any witnesses that we're waiting for?
No, both at the last minute were unable.
Okay, okay. So we have the parties here. There will not be witnesses other than the parties. And we have in the packet both the Law Department's memo, law report of May 6, 2024, the order we issued scheduling today for the evidentiary hearing. We have the amendment materials submitted by the complainant. There were materials submitted by Respondent, but they were witnesses who are no longer able to attend. So that is what we have before us. Okay, so we can begin. Again, I don't want to take the time to repeat our process if you have it down. Would you like to? Would you like to? So why don't we just then start with opening statements? If we want opening statements, we don't need that formality. If you'd like to just present, if you'd like to come up to the seat, or would you prefer sitting there? Your preference. Okay. Okay. And would you just introduce yourself?
John Griswold. As you stated, you have the packet that I sent, and it's basically Ms. Stiles did not file a 21 annual disclosure statement. In her 22, she left off owning property in Davidson County other than her primary residence. And then in her 23, it was due on March 31st, and it was filed on April 18th, the day after I filed the complaint.
Due on January 31st?
Due on January 31st.
Okay, right. Okay. And you have attached to your complaint, I'm sorry, to your materials that you submitted for us today.
That's a warranty deed that was filed on February the 25th of 22. Sorry.
Okay, so yeah, we can go. Special warranty deed filed
February 25th.
February 25th, 22. Okay. So the materials you have is, first you have this statement that there was no disclosure of the 2021 annual disclosure was not filed.
Correct.
Per the Metro Clerk's office.
I just want to point out that that's our order setting this hearing is only about 2022 and 2023.
Yeah, I realize. We're taking the evidence that he's putting before us, and that would go to, yeah, but just, I'm going through what he has.
That is correct.
So, and that's a date stamp from the, yeah. Then you have, second document you have is the website submission of, that's an electronically filed annual statement submitted on 1/23/23. That's for the calendar year 22. And then you have the annual disclosure statement filed just for the calendar year 23 and filed on April 18, 24. We have that with its attestation, and then we have a document called MLS Tax Suite. I'm not familiar with this
That's
document.
just showing the property and who owns it.
Okay, and is that,
When the deed was filed.
and that's something you get online? Or it's an MLS, okay, multi-listing service document. Okay, so that's a 1, 2, 3-page document. And then the last document is, as you said, the special warranty deed for the property with a certificate of authenticity. That is a true copy certificate. Okay. Okay. Is there anything you'd like to add to the documents you submitted as evidence? Is there anything you'd like to add?
No, ma'am.
Okay, thank you.
Question.
Yes.
Do you have any evidence that the property was not her residence during this time period?
Yes, sir, I do. I'd be more than happy to share it with you. It comes out of,
Oh, you also, had you attached, is this attached to the?
That came in with the submission.
Okay, I'm sorry.
it says in the January 5th, 2024 article that was in the Nashville Scene, Ms. Stiles, quote, states, quote, "It's my mother's house." Stiles tells the Scene, "I co-signed for it. I really wasn't thinking about it and wasn't trying to hide it. Taking care of your parents is not a crime last time I checked." End quote.
Thank you.
Yes, sir.
Any other questions about the materials for this party?
I have a question. Is the property at issue within the councilperson's district?
No, ma'am, it's in District 33.
This is the Clover Glen property. It's the Clover Glen subdivision. It's the Arrow Leaf.
Yes, ma'am.
It's the Arrow Leaf property. It's not in her district. Any other questions? Okay, so you rest.
Yes, ma'am.
Would you like to?
Sure, I'll come on back to the middle.
Okay. You have submitted a witness list, Rosie Hayes and Monica Bishop. They were not able to come. So you will, let's see. I could have sworn both of them, but I mean, I guess these are the public records, so we didn't.
Happy to swear again. Does my old one count? Do I need to do a new one?
You're just still under.
Okay, you're still under oath. You're still under oath.
Fantastic. So from the last time that we met, well, first let me say this. Thank you all, because you all just endured a modicum of my life for the last 9 months about Metro Arts. So thank you for listening. Thank you for taking it all in. I appreciate it. So for this particular case, the reality is this individual in the last hearing, it was portrayed to me as I sat here that he's one of my constituents and somehow wasn't responded to. That is not the case. He lives in Green Hills. He represents someone who owns land in my district. My process as a council person, and has been for the last 5 years, is I will speak to the individual or whoever's representing the company that owns land. We will have a conversation about what they would like to do. If it makes sense and it's something that I know the community would be interested in, it comes to my community meeting. From there, the community is good. We move forward, do the planning application. I am very big on not having protests at planning or in council for any reasons. So as I wanted to put this on the record, this piece of property in question, the original owners had someone pass away. They reached out to me, they asked me if they could put townhomes on the property. I said, no, that's density for density's sake. I really will, but I wasn't.
No, I have a question, I want to make sure I'm understanding things you're saying. So I was thinking property, the Arrowleaf, so tell us which property, can you just like give a name of the property or the lot number or something?
This is property on Mount View Road, his client owns it. That is where all of this stems from.
Okay.
So the original owners of the home, it was a family home. They asked me if I would support townhomes, and it is a small piece of property that has a cell tower on a portion of it. So there's really not a lot of land left to do a glut of townhomes. And so I told the original owners I wouldn't support it. After that, I didn't hear anything, and next thing I knew, the property had been sold. I received a phone call from the codes department, from Monica Bishop, who was one of the witnesses.
Mount View Road is in your district, right?
Yes, it is.
That's in your district, okay.
Yes. And so I received a phone call from Monica Bishop in Codes, who was going to be here today, to let me know that she had reached out to the new owner to say that they were going to condemn the structure that was sitting on the house and that they were going to tear it down.
The house itself?
Yes. She said, have they reached out to you? I said, they haven't, but tell them to reach out and we can talk about it. His client called me. He asked me the same question as the original owners, and I told him, I'm not gonna do townhomes if you'd like to have 2 cottages there perhaps, but density for density's sake, plus there's a huge drop-off behind the property, I'm not in support. After that, I received a phone call from Mr. Griswold, and he told me he didn't know that I had spoken to his client. And I said, I'm kind of in the midst of a few things right now, Metro Arts being the main thing, and that I would get back to him. I don't remember when, sometime after that, I answered the phone, and it was Mr. Griswold, and he wanted to talk about the property again, and I said, again, let me reach out to you. I haven't heard from your client. I prefer to deal with the people that own the land than realtors. It's been my experience, sometimes realtors don't really care what the community wants, but if you're talking to the people that own the land, it's a little bit more amenable. So with that, he started, after I said my piece, and I said I will give you a call back, he started to speak again. I said, sir, I'm going to hang up because I can't talk about this right now, and I have some bigger fish to fry right now. So then, from there, I then received an email from Vice Mayor Henderson letting me know that he had reached out. I also saw an email where he had reached out to the 5 at-large council members, thinking that perhaps they could step in and intervene and help out. Generally speaking, if you're unfamiliar, sometimes at-larges will step in if there's a need to take on a project and try and push it across the finish line. Those council members had heard from me. I had already shared, even with the vice mayor, I've already spoken to this client, I've spoken to this individual, I've let them know that I am not interested in the project right now. We can come back, but I got other stuff going on. So when that happened, when I found out about reaching out to Vice Mayor Henderson and also to the at-larges,
Was he reaching out for purposes of trying to get
rezone
support,
to find out
to get support, council support? That's why he was reaching
my
out.
support. So it's a property that has to be rezoned in order to do what he wanted to do.
I was just wondering, he was reaching out to these other council at large and the vice mayor so that you would then support it, or
supersede me, and that they would try and carry it.
They would carry it.
Because they hadn't heard from me.
Right,
so he was saying, I haven't heard from her.
But they could have gone to zoning and sponsored it or said, yes, we approve of this. Okay,
Right.
so he was trying to progress the project. Okay.
And basically go around. So needless to say, I called him back and I said, well, I'm aware of the emails, and so I'm not rezoning this. Don't call me.
Do you have final say?
Yes.
As district
yes.
council, you have final say of whether something's going to be rezoned? If district council opposes it, it just won't happen?
Correct.
I mean, that's informal with the planning commission or the board of zoning.
So before any of that happens, it comes, whoever owns a piece of property is coming to us to say, hey, my property is AR2A, could I turn it into,
Right. You go to
R5
your
or whatever?
home district.
You've got to go to your council member,
Right.
and they have to put in the paperwork for it to be rezoned.
But if your council member opposes it, are you saying?
If the council member opposes it, and so, for example, we had a situation like this in another district last term. The district council member didn't want to move it forward So the vice mayor asked an at-large council member to carry it.
Okay.
That particular council member, not very active, didn't push back and was like, okay, if you want to try it, go ahead.
Okay.
So the at-large came in and tried to push for it. It didn't go through.
Okay, but it could have gone through. An at-large could push something through even if the district council member is not supportive.
So my example that I gave you is that that council member
In this
told
case.
that at-large council member in the other case
Right.
that they could go ahead and do it.
Yeah.
But if I were to say, I'm against this,
I see what you're saying.
the at-large isn't gonna push
As a
it.
practical matter, it's not, okay, as a
They're
practical
not going to
matter.
do it. Because it creates strife, then you have to come on the floor and there's a battle between
Gotcha.
council members
I
over
understand.
something that's in
Yeah,
my
I get it.
district.
Gotcha.
So needless to say, as you saw, 24 phone calls, 15 text messages, that's harassing. I've already said now, I'll get back to you. I've told the client, you get back to me with what your plan is. I never heard from him again. Code said that they never heard from him again, and they tore the building down in the midst of all of this. And so 3 conversations were had, the last conversation being, don't email me again, don't call me again, because he was harassing me. And I had made it very clear, I will get back to you, clearly. So I know that you all dismissed that part, but I needed to lay that groundwork because the last hearing seemed like I just wasn't responding. And I am very communicative with my district, and that is well documented. So, to the 2 other items, and this is where I was saying we are not going to be here long. It is true, I did not include it on my disclosure by oversight, not by intention. I am not running an STR. I moved my mom down here to be close to me in her retirement. So I co-signed for her house. My mother pays for everything in that house. And so when we purchased the house, my mom actually lived with me for another year at my home.
When you purchased it, she lived with you for another?
I moved my mother down here, and I moved her in with me
Right, for
when
a
we
year.
signed for that, when we bought the house, did all the paperwork, so on and so forth. She lived with me still for another year.
And who was in the
beyond.
house that you
No
bought?
one.
You left it empty?
Just
for a
left it
year?
empty, and my mom was with me. And so when I filled out my disclosure that year, being perfectly honest, I wasn't thinking, oh, look, you've bought additional property in Davidson County. That wasn't my thought process at all. It was an oversight on my part. I am willfully admitting that. But we're sitting here because of a petty grievance from a realtor who didn't get their commission. And that's why I wanted to lay that initial groundwork in the beginning. This isn't because of, discrimination. This is, let me get at her because I didn't get what I wanted. So I did not include it on the 22. I'm readily admitting that. As for this year, I genuinely believe that I had submitted this year's disclosure at the same time I did the state, because they're all due on January 31st. And again, not an excuse, factually speaking, I have been dealing with a lot over these last few months, as we talked about a little bit briefly in the case before. So when I told him that I was dealing with bigger things, that is what I was dealing with. And I forgot. I forgot to file it, and when I got the email from the council office saying, we don't have your disclosure, my response was, really? And I had a conversation with Ms. Haynes, who is not here, to say, do you really not have my disclosure? I sent everything in on January 31st. And she said, maybe you just did the state, but we don't have ours. So I had responded and I had said, okay, I'll get it taken care of. And truthfully, again, forgot. Hence why, after this was filed, I did it immediately so it could be on record and updated it, made sure my mom's house was on there. I am not trying to hide funds. I do not have some secondary business where I'm making money. Again, this is my mother's home. And it was oversight on my part, and I'm admitting that. I've been filing my disclosures regularly for the rest of the time that I've been on council.
There's an allegation that you didn't file in your 21 annual disclosure, which would have been due in January 22, according to, is that?
I thought it was the 22
It's actually,
was
but he
missing.
went back, it's 22 is missing, but also, I guess,
what's before us is that 21 was also missing per the clerk's office. Is that what you
The
have?
22 was filed timely,
Oh, right.
and the complaint was made regarding the properties on the 22 and 23. While the hearing was pending, Mr. Griswold reached out to my office for all of her disclosures, and we discovered that the 2021 was not filed as well.
Oh,
So
okay.
it's
That's not before us today.
It's, well, yeah, it's evidentiary, it is.
Sure.
It's for context, it is.
Fair enough.
But question, so you said you're, for a year after you bought the house, I gotta name these properties,
So 4058 Arrowleaf is my mother's home.
So the Arrowleaf, for a year after you bought the Arrowleaf house, your mother continued to live
With me.
you in your
Yes.
home somewhere else, in your district, presumably.
In my district,
Okay,
yes.
for a year after.
Yes.
So you bought the house in February of '22.
What year are we in, 24?
Yeah, it's very hard. February of '22, you bought the house. You bought the house in February of '22.
Last year was 23, yes, because my mom finally moved into the house in June of last year.
June of '23. So when you filed in January of '23, your annual disclosure, and you had oversight and didn't include the Arrowleaf house.
Correct.
Your mother was living with you.
In my home.
And the house was
In 32,
empty.
correct.
So the house was empty, but you didn't, and you and your mother owned it as joint tenants with right of survivorship.
Yes.
But your mother was living with you, the house was empty, but it wasn't disclosed because,
Just oversight on my part. Nobody was in there.
Do you make any payments on the house yourself?
No, it's all my mom.
So you literally co-signed the
Correct.
note
and it's on the deed.
Yeah.
So, was it being rented or anything?
No.
It was just empty.
Yeah.
Who was
My
paying?
mom stayed with me. My mom.
Gas, electricity, all that,
Everything.
she just paid everything,
My mom.
she stayed with you.
Yes.
The house was completely
And just for the
empty.
record to state, I hate that we're having this conversation about my poor mom and her house
Of course.
because of a petty grievance.
Well, is filing disclosures about real estate owned petty?
If you get there because of what your original intention was, because the original intention wasn't, oh my gosh, I think Councilmember Stiles is hiding something from the
Right,
public.
right,
That's
right,
not where it came from. It
right,
came
right,
from,
right,
I'm
absolutely.
mad.
Right,
And what else can I
absolutely.
go for? Let me now go look at her disclosures.
So we saw, right, the original complaint had many allegations, most of which we dismissed
Yes.
because
So
we did
this
not
is,
raise.
this is,
No, I understand.
And
That's
again,
what you were referring to.
being my second
you were
time here,
referring to
based on personal
motivation.
stuff, yes.
Right. I just wanted to make sure that you didn't believe that the importance of filing annual
Oh, no,
disclosure-
that's why I'm being honest to say that it was an oversight on my part, but I'm not hiding money. People aren't giving me large sums that I haven't disclosed, none of those things. This is Joy being distracted, forgetful, and hence amending, making sure that when I filed this year's, everything is up to date.
I just
Do you
have a
have a
quick
question?
question for Metro
Oh,
Legal.
okay.
Which section or which provision of the code is this a potential violation of?
It's it's R 2.22.020R.
Can you just read it? I don't have it in front of me.
It says, if disclosure statements are required to be filed by the employee in accordance with this chapter, shall not fail or refuse to file in a timely manner all disclosure statements and reports, which statements and reports shall include all material information reasonably required to be included and shall not omit any material information reasonably necessary to make such reports complete and meaningful.
Okay. Do you have anything else to tell us? Or any other facts you'd like to
No, I think that's everything.
And let's see, so the annual disclosure statement itself is in the, it's not within the definition of the standards of conduct, which is, let's see. 1020, it follows in subsection 3.0, disclosures within the code, and it sets out the requirements of the annual disclosure there, and the form itself actually, with signed under penalties of perjury. So it is set out, its complete form, which says that basically, it says who has to file the disclosures in an effort to advance favorable opinions of the public, integrity of government, disclosure requirements are to be filed, and then it lists all of the individuals, the elected officials and others who have to file these annually on or before January 31st of each year. With a requirement to amend the disclosure statement within 30 days if there's a material change occurs. So you have 30 days to update it if there's a change. I do want to point out that, and this is, I think, why I totally understand what you said about the word petty was tied to the grievance, was tied to the motivation of the complaint. I get that, but
I'm not dismissing the disclosure part.
Right, because I do want to point out for the board that annual disclosures, it says right in the code, employees should recognize that the purpose of disclosure is to alleviate reasonable concerns, justified or not, of the public concerning possible conflicts and influences upon the employee's exercise of his or her official discretion. And I think particularly in light of the power that a district council member has to put a kibosh kind of on a project, right? I know it's not absolute, but you've described it so well. You need a council member to pursue a project. The importance of knowing what council members' disclosure statements say is just paramount to the whole process of the desire, the reason for the code. So
not at all negating that, ma'am.
Yeah, no, I understand that. But I will, and I understand that although he didn't allege that you didn't file in 21, is it your view that you didn't file in the 21 annual disclosure, which would have been due in 1/22, was again because of busyness, just oversight, yeah.
That is the truth. I think if you were to ask anyone about me, I am honest to a fault. So I don't have excuses.
Yeah.
I truly, in having the conversation with Ms. Haynes, didn't believe that I hadn't filed for this year.
Right.
And so if something wasn't filed, it was an oversight on my part, period. I think if I was running it at like 5 STRs and I didn't disclose them, I think that would be extremely shady of me.
Right. Although you understand that you're supposed to be disclosing any property you own, and I think might just be a matter of my circumstances, but the idea of having my name on a property that's almost $500,000 that I am on the title and the mortgage for, I just, that feels.
I'm not on the mortgage. I'm on the deed. I don't handle any of the financial responsibility of the home.
But
that is all my mom.
Right.
I signed for this house so I can have my mother here with me in her retirement.
When you say you signed for the house, you're
as in co-signing for the
co-signing
house.
what?
you're co-signing the mortgage. We co-sign, you're on the deed
Yes.
as owner. Your ownership.
Again, I'm just saying, for me, I don't think about this house ever.
I know, I understand.
think about it. I think, when I have to think about this house, that's the day I don't want to think about. Like,
I
when it's
understand,
my
because I
responsibility.
understand, you gotta cut the lawn, you gotta do this kind of stuff.
Well, when she's not here, is my point. That's for me.
Oh, I see, okay, because then it will come to you. Yeah, and it's a very hard topic for those of us with mothers. Okay, so you're on the deed, but, okay, any other questions? Oh, this is what I was gonna ask. You simultaneously have to file, there's a lot of filing you do as council members, and you have to file with the state as well, right? That's
Everything
what I
is
went through.
January 31st.
January 31st, so you like file state, you thought you filed everything, it's all
Yes.
electronics, you're sending things off, and you thought you had filed everything.
And I usually try and do it on the day that's due, because then it's like pressure, like, I gotta get to this.
Okay, and so, yeah, okay. So you're filing to the state, and you thought you filed with the...
With the city as well, yes.
We have had a failure to file. Okay. Any other questions before we?
Well, I'd just like to clarify, I don't think that it says shall not fail or refuse to file in a timely manner. As it relates to 2022 and 2023, 22 was filed, but it inadvertently omitted a property, and 23 was filed late. So it's not a failure or refusal to file.
Timely.
I mean, it wasn't timely, but it wasn't a refusal to file in a timely manner. It was just, she filed late.
Right, she filed, right. I mean, right, I don't think it was a refusal to, in 22 either, there wasn't a refusal to file.
I mean, she filed in 22.
It was an oversight.
Right, it was just an
But I'm saying in
oversight.
both cases, it wasn't a refusal. It was, I mean, what I'm hearing you say is you filed in 22 timely, but omitted the case, the house. And in 23, you
Thought that I had
thought you had filed. It was
Yes.
an oversight.
Yes.
And so.
And I will say that for the individual who brought the complaint, when I saw that, I was like, Mom's house. It really was a light bulb moment for me, like, oh my gosh, I didn't even think about this, because this is not my everyday. I'm not taking care of this house. Hence, when I submitted my disclosure, I made sure that it was on there, and it will be on there in perpetuity in any other new property. So, just
Okay.
being honest.
Okay. Any other questions, factual or clarifying? Anything about process? Is council office, do they help remind folks?
We,
Are they support?
so we really, for the $3 that we get paid, we are responsible for our own stuff. We get a reminder probably January 15th that says, hey, don't forget, January 31st, your disclosures are due. But in terms of it being a regular and a constant, a lot of it is left to us to get done. And so it's
And is there any
just
place you
juggling.
can go where, to council office, to just check to see that it's been filed, they've received it? Do they,
No.
they don't send you a, yay, thank you, it's been received?
No, we don't.
Little big green button or something, yay, you did it? Nothing like that, to
I'm
just
sorry.
make it easier? Nothing like that? It's just a reminder on January 15th, and that's it?
And then if we don't file it, then we get, like, I got a reminder, I think it was in March, saying, hey, we don't have it.
Oh, so they wait 2 months before they remind you that they didn't get it?
I mean, there's 40 of us, and I will say when we became incorporated, the circumstances of this city were vastly different. So what council office has to do now is exponentially more in general, because all of us are now filing major pieces of legislation. We've got meetings that can last 6 or 7 hours. So things like this, it's our accountability. It's on us.
It's not really like a support person that.
No.
Gotcha.
Unless we get an intern. And we don't even have a system for getting an intern.
Okay. Right, unlike fancy attorneys who have their
I mean, I'm envious of
secretaries.
everyone that has an assistant. I'm envious. If you got a spare one, throw them over here to the council office.
Gotcha, okay. Any other questions, thoughts, clarifications? Okay, well, thank you. I think you presented your facts very well, so do you have anything to add?
I'm doing a rebuttal.
Okay, yes, I'm sorry.
Madam Chair, I wasn't here for the other proceeding,
hold
and so I'm wondering, has he been sworn in? I know there was some statement that
Yes,
the
she had
council
been.
member has been.
He will,
be more than
he
happy
will
to.
be sworn in.
Yeah, and if he can affirm that the testimony he provided prior to being sworn in is true.
Yeah, he presented business records, he didn't really present any evidence.
He answered questions. I believe you asked him a question about, is this in this district, or,
Oh,
you know, so sometimes it's, yeah.
You asked me who,
That's
how do I know it's
Actual scene article.
yeah,
Yeah, we both asked the question,
Okay.
so.
okay.
Do you solemnly swear or affirm that the testimony you're about to give is truth and nothing but the truth?
I do, and also what I've already given.
And that oath applies to what you've already said today?
Yep. What I've already
Yes,
given,
yes,
yes, ma'am.
perfect.
I'm just kind of shocked we went to where we went. Okay. Boy, where do I start? First of all, I've never spoken with this woman until she called me in March. She says she has spoken to the new owners of that property. That property's been in the same family since the deed of, I'm sorry, I got the wrong one.
You're talking about the Mount View Road property?
Yes, ma'am. I apologize. It's been in the same family since 1965. There have been deeds recorded, but it's the same family. Matthew R. Nix and his 2 relatives inherited it from their grandfather, Mr. Love.
Until what date? And then it sold?
No, ma'am, they still own it.
They still own it?
It's been in their name since 1987.
Okay.
There is no cell tower on this land. There is not a house on this land. I don't know what's been condemned, but I don't think she's referencing the same property. It was part of a 5-acre estate.
5 acre.
That was split when Mr. Love died. And these boys got the 2 acres, and they sold off the 3 acres to the lady that owns it now. Okay? There is no easement on the property for a cell tower. Never has been.
Was there a cell tower on the 3 acres that were sold?
That I could not tell you, ma'am.
Okay. So there might have been. a cell
Could have
tower.
been.
Okay. But, okay.
What portion are you attempting, or did you want to have rezoned?
The 2, well,
2 acres.
here's the deal. This property is 2 acres. It's zoned AR2A agricultural. Okay?
It's zoned agricultural?
Yes, ma'am. So basically what I could do is put a mobile home on it. A single wide mobile home will go under agricultural. Don't think those people want that out there. And Mr. Nix has never spoken to his councilman.
Mr. Nix is your client?
Yes, is the operating partner, owner, and he has never spoken with Councilman Stiles about that land or anything else.
Mr. Nix owns the 2 acres,
Yes, ma'am.
and he is your client, he's trying to sell it,
Yes, ma'am.
and he'd like to have it rezoned before he sells it for townhouses so he
Oh,
can
no,
make more
ma'am.
money?
I don't know where townhouses came up. The 2 developers I was working with weren't even wanting townhouses. I was trying to get in touch with Miss Stiles to see what she would approve for on that property. I've talked to the neighbor and who spoken with Councilman Stiles, who I know would already not approve townhomes and apartments. We weren't asking for that. The two developers I was working with, who have told me they've never spoken to Councilman Stiles, but she claims that she has spoken to two developers and to the owner of the property. It's totally false. She did not speak to me, and I know she's a busy lady, but she did not speak with me until March the 29th of this year, after my numerous attempts to call and ask her, ma'am, what would you approve?
You said the 2-acre, father died with 5 acres, subdivided 2 acres and 3 acres. The 3 acres were sold to someone else, and the sons got the 2 acres. So there's 2
Well, nephews.
nephews. So the 2 nephews.
Well, there were 3, now there are 2.
2 nephews own the 2-acre lot. So although Mr. Nix is one of the nephews, there is another nephew.
That has not spoken with her either.
You know that?
Yes, ma'am.
Could we move to the allegations?
Yeah,
Well, no,
Actually-
no, excuse me. That's where I thought we were going. She opened this door.
So,
She opened the door.
Okay,
So
do
this
you have
is-
anything else to say about those
Oh, yes, I have
allegations?
lots to say. She opened the door.
Okay.
I've been sitting here since
Yeah.
8:45. And I really didn't anticipate this to take 10 minutes, because I was going to let all this stuff be gone.
Well, so from our vantage point, this either, this can go to her credibility, so you're welcome to say whatever you want about that, but the only thing we're really going to be considering is the 2022 and 2023 disclosure.
But she
understand.
attacked my credibility earlier by saying I was doing this as retaliation,
Okay.
not because I didn't get a commission, it's because she wouldn't call me.
I believe that we do need to let folks who come, who are,
I mean, I understand, I get what you say, I'm ready to go home too.
so,
That's quite all right.
And I know y'all get a lot of money to sit here.
right, I think what they're trying to do is to really just remind you that just, this is, but go ahead.
I didn't open the
finish-
door.
We understand. Finish what you're saying about this, what you feel like you need to say. We are listening, but then we will need to move to the.
I agree, yes ma'am.
Okay, let's go.
But I never spoke with her until she called me on the 29th, and she was very irritated that I had called the Vice Mayor's office. I did not contact 5 at large, I contacted 1. And that's when she said to me, I cannot believe, how dare you call the Vice Mayor's office on me? I will never rezone a piece of property to you, ever, and hung the phone up. No, it said, do not ever call me again, and then hung the phone up. Okay, I didn't harass her, I just was trying to get in touch with the councilman to do my client's service. There's my rebuttal.
Okay. Now, do you have anything to say on the substance of the annual disclosure statements? I assume you have the records before us, there's nothing else you have to say.
It can be
I mean, the testimony was that it was an oversight.
it can be an oversight, but it still wasn't done. There are a lot of tombstones in the cemetery that say it was an oversight.
Okay, thank you. Okay, so I think this is fairly straightforward, narrow facts, so I don't think we need any, I think we can close the evidence and turn to deliberations.
Was there, okay, so the respondent,
Well, we didn't.
nobody's doing closing arguments?
Oh, sure, yeah, we could, I'm sorry. Yeah, we could, and in fact, let's see, we didn't have cross-examination, are either you interested in asking questions of the other?
No, I want to go eat lunch.
Okay. Do you have any?
This is pretty important to me. I could wait on lunch.
Do you?
On closing
True.
order? Yes, ma'am.
That's true, my error. I did not go to cross-examination. So were there specific questions that, again, only related to the matter before us in the complaint? The other
straightforward.
issues were dismissed.
Pretty straightforward.
Okay, so you don't have any questions for the council member?
She's already stated it was an oversight. No,
Okay,
I have no
okay,
questions.
okay, so there's no, and you have no cross-examining questions for him? Okay, then there's no cross-examination. He's kind of given, we've allowed kind of rebuttal time, given the issues raised by a council member's testimony. So I think the evidence can
Yeah, if
be
there are no
closed.
closing.
If there's no, unless you want to have
arguments.
closing argument, would you like to make a closing argument on the annual disclosure issues?
Yes, ma'am.
Okay, you can close, give us your argument as to why.
No, it's not an argument, it's just a closing.
Okay, close.
I just want to say that from a press conference that Councilwoman Stiles had on June 18th, she said we're obligated as council members to represent our constituents. We represent our district and we represent the city. We must hold people accountable. She said, I'm willing to hold people accountable because I'm willing to pull the back of the curtain and expose shenanigans. And in that same press conference, she mentioned some paperwork, that ACH paperwork that was asked for, and the person received somebody else's paperwork with their security number, and she was quoted as saying that was pretty sloppy work by the legal department of Metro. Well, I believe it's equally sloppy for a council member, a paid Metro employee, to fail to file their annual disclosure statement as required by Section 2.222.030 of the Metropolitan Code. It's dreadful that Councilwoman Stiles didn't even file a disclosure statement in 21. She misled people on 22, and that her 23 statement was filed the day I filed my complaint. If our council members cannot manage the most basic tasks, how are we going to let them handle the bigger ones? And to quote her, we must hold people accountable.
Councilmember Stiles, would you like to make a closing statement or argument?
I guess briefly, just really to reiterate what I said before, as it being an oversight, again, a lot of things going on. And I did make those statements, and it is why I told you all the truth, that it was an oversight on my part. I'm not making excuses. I have to be held accountable as well, in the same way that I'm actively trying to hold others accountable for their actions. So I'm here to tell the truth and accept the decision that you will make. It's that simple. I again will say how we got there, although grateful that I know what the oversight was in leaving my mother's house off. How we got here should not be forgotten. Upset about no phone calls, that's how we got here.
Okay, thank you. Okay, that's the close of the evidence, and we can now turn to deliberation.
I guess I want to put aside all the motive evidence and really the he said, she said that we got. That's a lot of backstory. It doesn't particularly matter to what I think is the narrow task that we have before us, which is did she fail to file in a timely manner all disclosure statements and reports, and with respect to 2022, omit any material information reasonably necessary to make such reports complete and meaningful. My problem is I think these are fairly technical violations. I do think they are violations under the strict reading of the code. And then if they are violations, we get into, we have 4 options, and they're mandatory.
Yeah.
I'm curious what we've done in the past where we've had violations that we thought were more technical in nature. For example, don't we give council members a period to cure their failure to file by January 31st? And that we don't have a hearing on all that. We look at a list of people who didn't file.
Are you thinking, you're thinking of the lobbyists?
Okay. We don't do anything like that for council?
No. Count. So I will say, as I've said in many meetings, I think we have to separate whether we find a violation based on the facts versus this very odd limit we have to what we do if we find a violation. Let's keep those as two separate things. And address the first issue, is there a violation? And if there is, what we're going to do. And if there's not, then it's self-evident. So the question is, that you raised is there do we find a violation based on the facts, the documents before us?
I mean, I can make a motion that, based on the evidence presented to us, there's a finding that there is a technical violation of subsection R, failure to disclose under 2.222.020 standards of conduct.
For the year?
For the years, I think I'm only talking about 2022, which was
right.
Was filed timely but had an omission, and then the failure to timely file in 2023.
So for those, so the motion is for those 2 years.
Those 2 years.
Is there a second?
I'd second that, but I'd like to discuss.
Okay, and let's discuss.
I do think that I agree that conceptually it is right to separate the finding from the sanction, let's say. I do, there is sort of a nullification, there's a jury nullification opportunity too, but I find that there's a violation. I don't like what our options are for sanctions.
Well, I have a question about that, maybe for legal, because I agree with that. And if we have a vote on what my motion that I just made, and it carries, let's say hypothetically, then we would go to the actions, and if we don't have a vote of at least 4, then we don't take that action, then what happens? I feel like we've effectively taken care of the matter.
Well, we have had, this is not dissimilar from cases we've had in the past, this particular issue that you just raised.
Okay.
What if you find a violation, but you're not happy with your options? Well, we have done that in the past.
I just don't remember.
But we have found a violation and declined to issue sanctions.
Okay. So we believe we can do that under.
Yeah.
I think, that sounds reasonable.
Yes.
I mean, it doesn't read that way.
Yes, legally, I can only go by what's in the code, and as legal counsel, that's all I can do. It says if the board decides that a metro government elected official violated the standards of conduct, then the board shall take one or more of the following actions as decided by affirmative vote of at least 4 of its members. So that's what the code says.
But I read that to mean if we don't have a vote of at least 4 of its members, then we're within, that's the qualifier. We shall take that action, but it has to be by a vote of 4. So if we don't have 4, then we are not taking that action. But I still think that can dispose of the matter. I may be reading this very technically.
There's a different way to read it.
Okay,
the placement of these commas, the different way is not really helpful.
Okay.
But another way of reading is that the 4 votes are required to find the violation in the first place.
Right.
Yes,
Which is the issue we had last time.
That's also outlined in another provision of the code that makes it very clear
Right.
that any decision.
And maybe we just take the vote
let's go
on
step
that
by step.
first.
Yes, I think we should separate them and do a vote.
Well, I just want to say before we vote, just an observation. I think it's absurd that we can agree to some respect that there was troubling conduct that wasn't a violation of the code in the prior complaint, but then we come across a technical violation of the code and we are compelled to act on that. It's absurd to me that this is the outcome of this hearing and of this body. Like, I can't imagine that Nashville taxpayers expect their Board of Ethical Conduct to be constrained in this way. And I just wanted to say that I think it's absurd.
Talk about that provision that we're looking at.
Well,
the provision that says you have to file annual disclosures.
So
is
the part that you read about the reason for that, and I just lost the place. I think it's interesting to me, one, that this is not an income property. It's not being rented. The council member isn't collecting rents from this property. It's her mother's residence that she co-signed for. So the idea behind this requirement to me would be to disclose property in situations where there is some financial, like present financial interest in that property. I don't think technically she has a financial interest because she is a co-owner and, she has rights to, get a second mortgage or, do whatever she would like to with the property, but it's not presently like bringing her income or providing any financial benefit to her. It's her mother's residence. And so the idea behind requiring the disclosure to me is different from this situation, especially since it's not in her district. This property that her mother resides in is not in her district. So her decisions about rezoning property within her district would have no impact on what's happening with the Arrowleaf property that her mother owns, so that she co-owns. And so I just feel like this is really an abuse of the process for us to find a violation here. Now, technically, is it a violation? Yes. I don't see a way around that, but I'm just stating that it's absurd.
I mean, you could argue in this case that it was not material information reasonably required to be included or to make such reports complete and meaningful. That's not really a precedent that I'm comfortable with, though, is to say if you are a property owner, you don't have to disclose it. It's not material. I think it is, but I'm just saying that's another way to sort of get around that issue.
Even if it's not in your district, council members don't vote if something's going, like a big project or rezoning. I mean, even if it's not in your district, I think they could support or oppose it. They have the clout of being council. If they go to zoning and say, I don't think that project should go forward, and whether it's in their district or not, and if they have undisclosed ownership of real estate proximate to the development, I think the citizens of Nashville should be able to know that. I mean, if you found out that your council member put a kibosh on something that you were going to try to develop, and you later found out that council member owned property that would be impacted by it, you would feel like there was a failure of disclosure. I mean, I think that is the intent of these disclosures. This is a sympathetic case. I agree.
I'm not disputing the intent of the disclosure and the situation that you described. I don't know if one council person could end a rezoning in someone else's district if they wanted to. I don't know that. All I'm saying is, based on the situation that we have before us, I think this is an absurd result. That's it.
I'm hearing you say that it says located within Davidson County. It should be, actually, this applies to the mayor, to people in the mayor's office. That's why it's not just restricted to a council member's district. It's the whole Davidson County. But, okay, so it sounds like what you think is absurd is this annual disclosure requirement.
No.
Just in this instance.
What I've stated is that this case and the fact that we are basically presented with a situation where there's a technical violation of the code and we have to find that way based on how it's written and the facts before us, I think that's an absurd result when you compare it to the situation in the prior case where we could not proceed and get 4 votes to find a violation when there was obviously harm done. there's no indication here of a harm that we need to right. And so that's why I say this is an absurd result. Not the requirement, but the outcome.
But it sounds, you're expressing that very, very clearly. Do you see what you've just expressed moving to an action item? Is it actionable, your view?
I don't see how.
Okay.
I'm not going to attempt to twist and reinterpret the words to try to find that there's no violation. I don't think that's a good use of our time, and I don't think that that would set the right precedent going forward for us to do that. So I'm not suggesting that we try to find a way out of finding a violation. I'm just stating my discomfort with this whole outcome.
Okay. All right. So any other comments? There is a motion and a second, I believe, on the table to find an ethical violation for years, calendar year 22 and calendar year 23, as articulated. Ms. Carpenter. That's on the table. Is there any more discussion? Hearing none, let's take the vote.
Chair Diani?
Yes.
Ms. Carpenter?
Yes.
Ms. Grimes?
Yes.
Mr. Spraggins?
Yes.
Ms. Young?
Yes.
Okay. So we found a violation on the annual disclosures for those 2 years, and now we need to look at the very restrictive code provisions which authorize us to take action. And again, just to review them, the only options that the board, after finding an ethical violation, after hearing, can do is, by code, recommend to council that the elected official or member of the board or commission be censured. 2, recommend to the violating elected official that they resign their position. 3, refer the matter to the district attorney, criminal matter, or 4, refer it to the director of law, kind of on civil liability to try to restitution and other relief. Certainly, in my view, none of these options seem at all appropriate or proportional or to me, there's nothing here which would suggest a censure would be at all appropriate to what I'm hearing. I mean, so let's get rid of the criminal and the civil liability. So we're only looking at those 2. Censure, and that would be, we would send it to council for recommend a censure or recommend to the elected official that they consider resigning. That's what the code says.
So I think there's probably agreement on, among this board that none of those sanctions are appropriate. So I think technically someone would have to move to advance one of those sanctions, and then we would just vote according to our, belief on that. Shouldn't the sanction vote be separate from the violation vote?
Yes, it should, and we've just taken the violation vote, so with that is now action of the board. That is what we found, and now we move to the sanction section. I'm wondering if legal has any insight here, understanding what we are.
Well, what I can say is, any motion that's made and seconded, the board, in good faith, like any other board, tries to reach a decision by the required majority. And if for some reason, in good faith, the board is unable to reach a decision, then you're unable to reach a decision in good faith, if that's actually what occurred. That's all I can say. But again, the code section says, you shall, by a vote of at least 4. So my advice is to, in good faith, try to reach a decision. And that's all I can really say.
Is there any difference from a good faith perspective if the sanction fails for lack of motion as opposed to a motion that's made and seconded and then fails?
Well, the way the code is written, it includes the expectation that there's some attempt that, by this board to take action. So that's the way it's written.
I didn't review before this. There was we had a hearing many years ago where we found a violation or a technical violation, but we found that none of the sanction authority were appropriate. And we put that into the order that we find as a group, we vote on it and find that in light of the violation and the nature of the violation, we considered our sanction authority under this provision and found that none were appropriate. And so we declined to issue a sanction.
What I can say, I really don't have a recollection on that.
Yeah.
So I can't comment
It's
on
a
that
planning
because
board.
I just don't,
Yeah, right.
I don't want to say something that I don't have the
Okay.
full facts on. I just don't,
Okay.
it's not coming to mind right now.
What about tweaking these? So, for instance, we could modify the language, perhaps, of these actions to say.
The only thought I had was that we could recommend to the council that the elected official be censured but really make that recommendation a speaking recommendation that says this was a technical violation, we don't have the right authorities, you need to change this, whatever, and then they can ignore the censure part of the recommendation. But
Right.
I don't think that's perfect either.
Yeah, or we could do it with what I was thinking along those same lines, with the second one, we're not going to recommend to the elected official that they resign, but we could say, we recommend that the elected official really attend to timely, accurate filing of annual disclosures going forward, and that if for any reason they're unable to do that or refuse to do that, they should consider resigning. You could even do it that way, which is just to the individual elected official, saying, we value the annual, we think the annual, it's in the code, and we think it's important. And you should do that going forward. So it's almost more of a, if you can't do that, you shouldn't be where you are. So it's not, so it's like, that's what I mean by tweaking, or your suggestion.
Down that path, I would address it to all council members, say this should just serve as a reminder to everyone, file these things by January 31st and include any property that you might have interest in or something.
You mean wait, so you'd be modifying the first paragraph?
Yeah, it would be a very half-hearted recommendation for censure, but then pivot to say, we don't have the tools to not do this. Mm-hmm. We're required to do this. Mm-hmm. And then we recommend that everyone pay attention to this rule mm-hmm. and consider legislation to give us new tools if you think this is too much.
Yeah.
Or we can just vote for no sanction, and if Mr. Griswold wants to take that up to the court, he can.
I actually was looking at, again, to modify it at the second one, I thought, rather than sending it to council, that feels bigger, to send it to council, essentially, a finding of a violation, to send it to colleagues.
I just had a question. I'm just.
Yeah.
And sitting here with my council hat on, again, to the needs of things that need to be tweaked and fixed. But if you have a recollection of an action that was actually done, is it precluded from the body being able to do it because she doesn't remember it happening?
Well,
if it happened.
wish, I believe it's the planning board, it was a technical violation, we decided it didn't want, it was roast. So I should have looked at it and copied it and reviewed it before I came. It's a vague recollection. We try to keep some level of institutional knowledge, but it's hard. But that question is, no, that's a fair question. We can do what we want. I mean,
Right,
legal is
okay.
it gives us advice.
Right, okay.
A very trusted advisor here, a
Yeah,
very
same.
knowledgeable,
I just
trusted
wanted to be
advisor,
sure.
but no, yes.
I go back to, under action of the board, the board shall take the action, but it has to be an affirmative vote. We're not gonna have an affirmative vote, I suspect, based on the discussion for the members for any of these. So can we not just move that we don't have that?
Yeah.
Yeah, and similarly.
Well, let me say something. You really, the only way the board acts is through votes.
No, I
So
understand.
through motions that are seconded, so
I was saying maybe
you actually have to go ahead and do it.
Right.
And that's what determines what the votes
do
are.
it.
Okay.
That's what I was saying
The
at the
other thing, I mean,
beginning, like,
if you look in the sanctions section, 050, it also says the council shall, adopt by an affirmative vote of 21 members. And obviously shall there isn't requiring the council
Because-
to do that. It's
because they
requiring
have
them
not.
to take the vote on it.
Yes,
Right.
and they have not
All right.
even taken the
That should
vote.
be changed to may take.
Yeah.
There was an instance where we sent up for censure and the council refused, and it says shall.
Right. So shall doesn't mean that we have to
Shall
actually
didn't mean
go
it
through
for
with it.
council, it doesn't necessarily mean it for us.
So I move for the purpose of fulfilling our duties, that we recommend to the council that the council member be censured, although I do not think that that is really the right course of action.
I second the motion.
How was that? Oh my God.
Let's have a vote.
And then we'll just vote.
Okay, so the motion is that we recommend to the council that the elected official be censured for the ethical violations with respect to annual disclosure for 22 and 23. Okay, that's the motion. It's been seconded. Any discussion? And you're making that motion rather than tweaking the language that you had proposed before?
Correct.
Okay.
Chair Diani?
No.
Ms. Carpenter?
No.
Ms. Grimes?
No.
Mr. Spraggins?
No?
Ms. Young?
No.
I make a
We
motion.
have 5 noes?
We got 5 noes.
Oh.
I make a recommendation that, as a sanction, we recommend to the respondent that in the event she cannot, going forward, file accurate and timely annual disclosure statements with Metro government, she should consider resigning. That's my motion. Is there a second? So it's the number 2, but with a conditional, saying, if you can't do this, you should resign. You should consider resigning if you can't do what's required of you as an elected official. So it softens the second. Is there a second? Okay, hearing none, that fails. So then I will move to say, recommend to the violating election official or member of the board or commission resign his or her respective position. Do I have a second? So there's no second on that. There's no way we're gonna waste our time with the other 2. So the order then will be that the board found today an ethical violation for those 2 years, two ethical violations for each year, and that the board was unable to agree to sanctions proportionate to the nature of the violation. Is that?
Well, I would change that language, because I don't think, that makes it sound as if there was disagreement among the
Yeah.
board, and there
Mhm.
wasn't.
So just, you can.
Say the board
provide the-
considered sanctions which
Inappropriate.
failed to get 4 votes.
Right.
Yeah.
Well, that doesn't well describe our dilemma. Our dilemma is that we don't have an option that's appropriate to the nature of the offense. So, for instance, the code could include that we could provide a warning to the party
Right, but I don't think
created a
that in this
violation.
order, do we?
No, I think that's something we take up with the council.
No, that's what I'm saying. That's what.
But I don't think it needs to be in this order.
No. But
Okay,
I'm
okay. I thought we were still discussing the language of the order, so I'm sorry.
no.
Okay,
But we might want to follow up with
agreed.
that type of.
Yep.
So do you have? So where do things stand?
Where things stand is the board found a violation, and the board, on the sanctions motion, the one sanction that was seconded, the board voted no. Unanimously.
Would you include what that sanction proposal was, which will be in the
Well,
minutes?
the sanction to recommend that the council member be censured for the ethical violation. So that was the motion, and it was seconded, and it was no, 5-0. So it did not pass. So essentially, yeah, it's what it is.
Okay. I think the order might need some type of summary statement which said, so
Well, I
no
think-
sanctions are being imposed. That is what we are doing as a board.
Well,
We are not,
it,
that feels very,
your actions, the vote is what reflects your actions. The motion and the second, and the vote on the motion and second
Failed.
reflects the action of the board.
and that motion failed. Okay. Okay, so we are done with that. The only other matter, I think, is the next steps. And I just, I'm going to ask our board secretary to comment on our membership.
Yeah, we still have a vacancy from the Nashville Central Labor Council, and I have been in contact with that president, and they're still searching for their eligible candidate to fill that position, but as of right now, we're still vacant.
I don't think we're inspiring any new members to join.
I think they are avoiding it.
The exact same thought.
They're just clamoring to get on the board.
Will the chair entertain a motion to adjourn?
I will entertain a motion to adjourn.
Second.
Okay, all in favor, say aye. Aye. We are adjourned. Thank you all.